Good morning, everybody. It's 5 minutes after 11. I'd like to officially call the Will County Board Land Use and Development meeting to order. If you will all please rise with me for the Pledge of Allegiance. And I will ask Director DuBois, if you don't mind, leading us in the pledge today.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everybody. Dawn, will you please go ahead and call the roll?
Good morning. Denise Winfrey,
Here.
Judy Ogala,
Here.
Raquel Mitchell, Dawn Bullock, Herbert Brooks, Sherry Newquist, and Chairman Frankie Pretzel.
I'm here. Thank you. Okay, I'm looking for a motion for approval of the minutes from the Will County Land Use and Development Committee regular meeting, November 12th, 2024.
I'll make that
We have a motion, Winfrey.
second, O'Gala.
Dawn, please call the roll on that one.
Denise Winfrey,
Yes.
Judy Ogala,
Yes.
Herbert Brooks. Chairman Frankie Pretzel.
Yes. Okay, motion carries. First on the agenda under new business today. Ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case ZC 24066. RE Land IL IV Inc., owner of record, requesting a map amendment from A1 to I3. Also a special use permit for mining, quarrying with blasting or other use of explosives. Another special use permit for concrete and asphalt mixing. And a third special use permit for clean construction or demolition debris. Fill operations. A variance for the location of open pits and shafts from the side property line from 50 feet to 0 feet. A variance for the location of open pits and shafts from the side property line from 50 feet to 0 feet. And this one's in Wheatland Township, commonly known as southeast corner of Essington Road and 127th Street, Bolingbrook, Illinois, County Board District Number 9. Can I please get a motion and a second to put this on the floor?
Motion, O'Gala.
Second. We have a motion and a second. And Marguerite, I will turn it over to you for some more clarification on this case.
Thank you, Chair Pretzel. So this zoning case, ZC 24066, as mentioned, takes place in Wheatland Township. The owner is RE Land IL4 Inc., where Artem Zakharov is 100% shareholder, sole officer, and sole director. The agent, Artem Zakharov, and the attorney is William Graft of Graft and Jordan. Co-counsel is Reagan Patterson and Mike Martin of Martin, Dunbeck, and Miller. Reagan is, I believe, give me one sec. My apologies for not recalling what firm she represents. But this property is located, as mentioned, southeast corner of Essington Road and Reagan Road. The property consists of 3 different PIN numbers. To the south, it has an existing quarry, which is AZ Hard Rock, and this particular 3 pins are the expansion of that quarry. So the property is surrounded by the village of Bolingbrook to the immediate north, south, east, and west. And the existing AZ Hard Rock quarry is actually annexed within the village of Bolingbrook. The village of Plainfield is located at the southwest corner of the subject property, where the Lakeland subdivision is located, and the village of Romeoville is located south of I-55. There are 6 main traffic roads around the subject property. So there are many different vehicles that use this property. There are major subdivisions in this area. The property contains Lily Catch Creek. So there is floodplains and was formerly a surface mine area to the southeast of the property. I can pull up an aerial of the property shortly. But with this, the applicant is looking to propose to surface mine the southeast portion of the property. It was previously rezoned to I3 back in the 1970s, and then was abandoned. So with that, wetlands developed in the areas that were formerly surface mined. The applicant identified limestone resources and dolomite limestone underneath. So they would be proposing to do underground mining under Lily Cache Creek and to the northwest of the subject property. With regards to that, they are proposing to blast because that's how you mine limestone. It would be at most twice a week. It does take some preparation for the blasting to propose what they are planning on with the tonnage of aggregate that comes from a blast. And then it takes time with the blasting engineers to appropriately size the blast and fill those job orders associated with it. With that, the county has regulations regarding when blasting can occur, and also prohibits it during many of the holidays. The applicant is required to obtain state permits for the mining and quarrying. Part of that is they have to refill basically fill in their quarry operations back to the grade that it started at. And that's part of the requirements of the state permit. They are proposing to use clean construction demolition debris over the entire site. So with the surface mining, they would be bringing in clean construction fill. Again, it is very heavily regulated at the state and local levels. And then they are proposing, since aggregate is also used for concrete mixing, to have asphalt grinding and mixing operations on site, which would be in the existing I3 area. The clean construction demolition and quarrying would be applicable to the entire site. The proposed hours of operation would be 7 a.m. to 7 p.m. Monday through Friday, 7 a.m. to 3 p.m. on Saturdays. Really, it just follows the construction job site schedules. So they would be filling orders for those types of construction projects, a lot of roadway improvements, things like that, and they'd be open during those hours. The same employees are expected to work at AZ Hard Rock, so they aren't predicting an expansion in employment at this time. So in terms of the impacts to the roadways, things like that, it would be very similar to the existing conditions. Essington Road to the north has a weight limit, as does 127 to the south. Also has a weight restriction, so really the trucks, when they are filled with rock, are only limited to use Remington, Weber Road to get to I-55, and roadways in that area. The applicant is proposing to put an 18-foot tall berm along the areas to the west and north of the property. With that, to meet the county standards, that berm would be about 113 feet wide and would have a 5-foot plantable top with evergreen trees and deciduous canopy trees, shrubs. With that, the applicant has to be 200 feet from that property line along Essington and 127 to the north. From there, the variances at the Planning and Zoning Commission were denied. You'll actually hear the appeal of that case later on in this meeting. But with regards to that, that is to apply so that the existing quarry could cross property lines. They are not requesting a 50-foot setback from any of the property lines that abut the roadways. At the Planning and Zoning Commission, numerous residents spoke in objection, and staff received many emails of objection, many concerned with potential sinkholes or damage to their structures just from the blasting vibrations that occur with these types of uses. There's concerns of the I3 district related to the school that is across the street immediately to the west. That's Liberty School. There's underground mining concerns. There's a pipeline in the area, so there's concerns with vibrations and impacting that. Many of those are provided in the statement of facts. The village of Bolingbrook and the village of Plainfield have submitted valid legal objections. So with regards to the map amendment request, A 3/4 supermajority vote would be required at county board to approve the map amendment to the I3. With regards to that, they are requesting I3 for the clean construction demolition debris, essentially. The special uses for mining and quarrying would be permitted in A1 district through a special use approval, but with the remediation of the quarry, they want to do it with a clean construction demolition type application, and that's only permitted through special use approval in the I3 district. With that, the school district, so the Plainfield Consolidated School District 202, also submitted a letter of objection. And in terms of, just so you're aware of how many emails staff has received, it's about 229 emails objecting and stating some concerns regarding this use. Of that, I'm happy to answer any questions, and I know the applicant is here with his team to answer any questions you might have.
Okay, thank you, Margie. And I do see the applicant is here. If you guys want to step up to the microphone over here, we'll give you guys a chance to talk and answer any questions. But do we have any questions from this committee for staff before we do that?
I have a question, Marguerite. So with the variance that they're asking for, is this something that we would do for other situations, or is this just unique to this type of position here? And are they able to operate if it were to pass without those variances?
In terms of the variances, with related, let me pull up the image, but so the screen there just shows kind of the layout of the different special uses. But if you look immediately south, which is kind of cut off for the bottom of the screen, that's the existing quarry. So you can kind of see in that image, the existing quarry. Really, the area in the orange dotted line would be, the quarry would just extend north. So in this situation, that would be applicable. We had another instance a few years ago where there was an area left within another quarry that they came forward. They needed the variances for this exact same request of 50 feet from the side property lines to just remove that island left within the center of the quarry. So sometimes this does happen with quarries if they want to expand. Instead of having a 50-foot wide buffer that separates the two quarries, they would just continue on and be able to use the limestone and aggregate that they can get from that area.
Thank you, that makes sense.
And I have a question for you. So the applicant is offering to put an 18-foot berm, which you said would have to be about 120 feet wide, but essentially would create a 200-foot barrier between the edge of the property line and any work that's being done. Is that on the upper left side, or is it around the?
Yeah, so the image I have on the screen right now, the area in orange is the proposed berm. Now with Lily Cash Creek running through the property, and that is a regulated floodway, of course, berms can't stop the flow of water. So the berm will have to be cut and designed to not impact the floodwaters. But in terms of the areas, they are looking to establish that berm along the residential uses to the north and west, and a little bit to the east in the northeast corner.
So essentially, there's a 200-foot gap between the property line edge and any work that can be done if that berm is there.
That's correct. And that would include going down into the ground as well.
And 18 feet high with also some additional landscaping.
Correct.
Any other questions for Margie? All right, I see Mr. Davidson is up at the microphone. Please introduce yourself and make sure your microphone is on.
Good morning.
No, it's not on. Hit that button there.
Good morning. Good morning, Chairman Pretzel, Marguerite. My name is Gary Davidson. I am with Castle Law. We're a law firm here in Joliet, Illinois. I want to introduce the rest of the team that is with me. My co-counsel, Bill Graft. Bill knows a lot more of the background and substance on this, as I've recently been brought on. My colleague, John Curran at Castle Law, as well as the following expert witnesses that we have here. Should you have any questions that pertain to them. We're not going to make this a 3-hour meeting. I have them here only if there's questions that the board has. So we have Mike Hennessy. Mike is the mine operator at AZ Hard Rock. We have Michael Shampsis, who is a professional engineer at Landmark Engineering. We have Charles Palmcook, who is a mine safety engineer at Quick Supply Company. We have Michael Worthman, a professional engineer and traffic consultant at KLOA Inc. We also have Michael Maroos at Maroos and Company, and Ronald Schrack, professional engineer at Schrack Environmental Consulting Inc. Just by way of a 10,000-foot overview, and then if you have any questions, all of the team members are here for the questions that might pertain to them. This is a parcel that has been mined since the 50s, if you look back at the GIS maps. In fact, any subdivisions like the Lakelands that was built close there, the mining operations have been continuous and uninterrupted during the time that that subdivision was built. Shortly prior to the applicant purchasing this land, the berms were brought down by the prior owner, and I think that is when people realized that there was a quarry operation going on. I happen to know a considerable amount about quarry operations only because I represent Lafarge. Most people here wouldn't realize, but if you drive down Route 80, there's underground mines that are adjacent to Route 80 next to subdivisions. The amount of decibels of disruption that occurs in an underground mining operation is non-existent. Traffic, fire engines, kids playing in backyards create more sound. No one even recognized that this quarry operation was in existence until that berm came down. The biggest thing with the county that all of you know, being on this committee, is that the county does not like split zoning. And this is really just correcting the split zoning and resolving that issue. And that would be consistent with the zoning plans allowing for the conducting of this activity at this parcel. This particular project has always and will continue to do so, employ many union jobs and prevailing wage, which is why Tom White from the Three Rivers Construction Alliance, and there were some letters of support that I think Marguerite might have forgot to mention from the 150 operators who are also in support of this project. So we've got a tremendous amount of jobs and union members who are counting on continuing to operate when this project moves forward. Obviously, the existing quarry and mine will continue to operate irrespective of what this board were to approve. But if this were to pass, which we believe that we've met all the criteria, that berm will now go back up and more jobs will be created. Again, there's some discussion about the wetlands. We anticipate within the next few weeks, although we're talking about the federal government, so weeks could be months, but we anticipate that this should be removed from any floodplain and wetland determination, and that it will be taken out of that based on our feedback from both the IEPA and the Army Corps of Engineers. The other thing that I find in development projects, and we often find, is that whether it's residential, industrial, or commercial development, these projects oftentimes solve flooding issues. And you probably know that Essington Road oftentimes floods to the point where the waters from the Lily Cache Creek go over it, making it impassable. Our particular project will actually solve that problem because we will have retention on site that will take on that water. So we've met all the county requirements. We've met all the standards for the special use, and we're here to answer questions.
Thank you. Questions from the committee for Mr. Davidson or his team?
Thank you. So I have questions. So the current construction site or mining site, are you guys having explosions, mining explosions happening now? And how often do they occur?
Yes, they happen 1 to 2 times a week. That's been consistent.
And during any of that time, I'm sorry, my voice is crazy. During any of that time, have you had residents complain about any noise or disruption that happened?
I'll defer to Mr. Graff on that.
Not that we're aware of. We try to be a good neighbor. We've met with neighbors. We've asked them to come over and witness blasts. We're blasting, as Mr. Davis has said, twice a week. We have vibration monitors on site. In fact, there are several of them. There's one on Essington Road that's far from the area of the existing quarry. And we meet and exceed all state and MSHA requirements for all blasts.
Okay.
We're underneath the criteria.
And the existing pipeline, I don't know where it is on the map. Marguerite, do you have a picture of that? Things download to the iPad really slow.
I do not. It's my understanding it exists within the subdivisions to the southeast, but there was nothing shown on the plat survey for the subject property.
Okay, and this map where the southeast is
It would be to the bottom
to
left.
the bottom left, okay. So you've not had any disturbance there with the current blasting with the pipeline either, right?
No.
Okay, all right. And the owner of this property wants to take this existing mine and take it and expand so that we can continue to get limestone out of the area. And if they don't do this, if they're not allowed to do this, then what happens with the existing site? How long can that be in operation, do you know?
I thought it was 5 to 7 years.
5 to 7 years.
5 to
of
7
remaining
years.
Stone left, yes.
Okay. And then with this plan, expanding to this new property, which is right there, the intent would be to continue that and we'll give life expectancy for about how long for the process?
Another 10 to 15 years on the surface. Remember, we're not mining the surface west of Lily Cache Creek. And then the underground would be the high quality dolomite. They call it superstructure limestone.
Okay, for 10 to 15 years?
Well, that may be for 20 or 30.
Oh, we
And
don't-
It
we
needs
don't
to be
know.
economically viable because they're using pillars and columns. Each of those blasts underground are 20% of the blasts on the surface in terms of charge. And
Okay.
that's required by MSHA.
Okay, and how many employees currently work there, and would the same amount be used for, and I know you guys said it, and I'm sorry, I forgot, that same amount of employees would continue to overflow, so you wouldn't begin right away on this new property, or you would?
Assuming that we were fortunate enough to have approval, we have a site plan approval process and permitting process with your staff, and we expect that would take some time. And we would like to mobilize as quickly as we can to prepare. There are lots of U.S. Army Corps, FEMA permits, MSHA permits, IEPA permits, and we have those in the current quarry. We're in full compliance with every one of those permits. We would just want to continue those to the new property.
Okay, and we're not aware, Marguerite, of any issues that they have had with their permits that they've had from the state and federal government for all those things. They've never had any issues with them, do you know?
Off the top of my head, no. In terms of, they have a ROS permit with IEPA, which is basically for small source pollutants. They've been in compliance with that.
Okay, and again, how many employees do we have here?
I think about,
Approximate is fine,
Mike, 15? Yeah. About 15 employees.
15 employees. Okay,
Mhm.
thank you.
Do you a second? The
And that
limestone.
does not include third-party contractors that might be 150 operators and.
Right, people that haul out of there, right?
The resource is used for all construction, for all municipalities, for the county. The limestone goes into county projects either directly or through county bidding, and is used for footings and foundations, for industrial buildings, for road beds, and for bridges and other structures. So limestone is a resource that's there. So,
That was actually my question. How much of the limestone that we get from the quarry is used locally or in?
well, transportation is one of the largest components of the industry. So the projects that are further away are less economically viable because of trucking back and forth. And so the areas, all of Will County, some of DuPage, even some of Cook, and the sand and gravel that's coincidental on the surface of the subject property. Margie had, you had the aerial up. See the ball, almost looks like bear claws in the far southwest portion. That's the portion that's split zoned already in the county. That area that Margie's pointed out is the sand and gravel was dredged, and there's lots of sand and gravel all the way north. And so that is rarer in the Chicago metropolitan area. In general, I learned this from the 150 operators engineers. There's about 60 million tons of dolomite used in the Chicago metropolitan area every year for rebuilding roads and construction. So
So if we're not getting it from here, it's safe to say that we're transporting it in from farther away.
Yes.
By using
Yeah,
truck
like
and,
down in like Joe Van Dyne's district, all those strip malls down in the Wilmington area, if you guys are familiar with that. Those are all, old strip mines and still existing quarry operations. That's why you have your deconstructions and those folks that are all down in that Morris area.
all right. And then last, you said there's never going to be any above ground mining to the left or west of Lily Cache Creek there.
that's right. That's our plan in our application and the plans. In fact, there'll be a private stormwater flood control project that our client will pay for. And our civil engineers here with some calculations of what public benefit that provides. Would you mind if I called up our civil engineer because it's his design to put a flood control system west of the creek to
Sure.
alleviate the overtopping of the road and the flooding of the school and ready, set, ride and downstream.
Yeah,
Would that
please.
be helpful for the
Yeah,
committee?
This is your chance.
Okay.
Mr. Shamsi? Mr. Shamsi's resume is in the materials. I think he's licensed in over 20 states as a PE.
Good morning. So our initial design for the flood control project on site involves a 635 acre feet of storage, which is about 200 million gallons. And we're going to store that water and slowly release it. Right now, I believe the flow going through Lily Cache Creek at Essington is around, I think, 5,700 CFS. And we're going to drop that down to about 3,800 CFS as our maximum flow. And so I think we have a 30% reduction under the 100-year event and a 55% reduction under the 2-year event. So we substantially reduced the flow of water going under Essington at the bridge, and which will alleviate the overtopping, and we're storing it and slowly releasing from there. And we're releasing it by mechanical means because our basin will be deeper than the creek, so we'll have a pump station, so we can definitely control it with a pump station.
Member Brooks, I know you've been patiently waiting over there.
Thank you. One question for you, gentlemen, and Marguerite, I do have one for you. You mentioned in your process multi-permits. If passed by the board, 22 members, 2/3 it would take to pass. In those multi-permits, if say, for example, you are denied one of them, of the multi, what would happen with your process?
We wouldn't be able to proceed. So,
One,
right, mining industry is regulated by the federal government and the state in MSHA. So local entities obviously have land use control, but the permits, we have an IEPA permit. Margie didn't mention that. It's an outfall permit to the existing quarry. We test that every month. We're in full compliance. We're well under the standards. Our environmental engineers here, if you have follow-up questions on that. But we'll need the federal and state permit.
federal and state.
Yes.
All right. Thank you.
And very, very good question. And as you know, Mr. Brooks, the good thing about Illinois is we have more governmental entities than any other state. The bad news about Illinois is we have more governmental entities than any other state.
I get it.
So we will have lots of eyes on this to make sure that we're
Okay.
in full compliance.
Thank you, gentlemen. And Marguerite, my question to you is, the gentleman alluded to, you opened up with over 220 emails that have been received. But what you didn't tell us is the good news and the bad news. So I didn't know the operation engineer had endorsed. So can you tell me a little bit? I know we got a lot of letters and emails, but those, how many of them did you get that endorsed this project for the gentleman?
So we did receive one letter of support, and it was from a member of the Local 150 union. And he mentioned that he worked in that industry and, you know, is able to raise a family in the county and a resident within the county. I did perform a site visit with the plant engineer, Mr. Hennessy. And with that, he mentioned, you know, he lives local. Most of the employees live local. And it's, you know, a working relationship with the community. He's working with the local unions, the local community college, to potentially work on getting educational programs within Limestone. If I go back to my early school days, I seem to remember Limestone, you do get a lot of fossils and things like that. So that's, again, educational opportunities that are an option too.
Okay. And Marguerite, I was here a couple weeks ago for the planning and zoning meeting on that Tuesday night. But like most of those meetings, they were very long and I hadn't had dinner. You didn't bring it, so I left. And I understand that they did deny.
They did, and I did not cover that in my summary, and I apologize, but the Planning and Zoning Commission unanimously voted to oppose all the map amendment, the 3 special uses, as well as the 2 variances. And with that, I do want to point out with the special uses, no, I did cover that. Never mind.
Thank you, Marguerite. Mr. Chairman, thank you.
Any other questions for the applicant's team? Okay, don't go far, but you guys can.
Just one, just additional thing that kind of just piggybacks on what Mr. Brooks said. Myself and my colleague, John Curran, were not involved in this project prior to that Planning and Zoning Commission. When the applicant requested that we represent them, John and I have a fairly high standard. We made some requests of them. We said we wanted to make sure that we were going to be good neighbors, that we were going to rebuild this berm, that we were going to take into account the concerns that Marguerite had, because quite frankly, the next 2 items on the agenda are with my firm as well. So I want to make sure that I have credibility when I come back here the next time. And they satisfied John and my concerns and indicated they would do that. And that's why John and I had decided to endorse this.
Thank you. Okay, I know there's other people in attendance to speak on this case. I know the Village of Bolingbrook. I invite you all up to the microphone now if you'd like to make comment on this. Welcome. Start by saying your name so we know.
Yes. John Argadelis, Mayor of Plainfield. I know we have some residents here who would like to speak as well. And it's good to see some familiar faces I served with in the past here. So about 12 years ago, I sat on the land use committee, and we had a quarry issue come up. And it was a situation where there was a quarry on Naperville Road in Plainfield. And the quarry was there first. It had been in operations for a long time. And then residential developments came around it. And in that case, the residents were objecting to the continued use of the quarry under the current zoning at the time. They wanted it to go backwards, if you will. And we know, as a lawyer and as county board members, we all know that zoning that's in existence, that's an absolute right of that. That's a property right of that ownership. They cannot have that taken away from them. But we need to look at this as a new project. because essentially what they're asking to do is greatly intensify what's going on there. So this is like saying, okay, we're going to plop a new quarry down where existing houses are. So it's a very different situation than what we've dealt with in the past, where existing businesses should be allowed to continue to work. And when we talk about this has been around since the 50s, in its current state since the 50s, not in its greatly expanded state that the applicant's seeking to do right now. I do have a question for staff to clarify, and I don't know your last name, but I don't want to call you by your first name. It's impolite. But it seems to me, at least from what we were looking at, that the berm is 18 feet wide, not 18 feet high. Is that correct?
So the proposed berm is going to be 18 feet tall, and that based on a slope ratio of 3 feet, 3-to-1 ratio, essentially, that would equate to 113 feet wide
Okay.
on the property.
Okay, thank you. So I do want to reiterate, I did send a letter, and I think it should be in your packages, that the Plainfield Village Board did unanimously adopt an ordinance in opposition to all of the requests being made here. You know, and I look at this thing as well, and I know as Mayor of Plainfield on the county board in the past, we always have to look at pros and cons and what's the overall good. If there's something very, very good for the county, but some residents don't want it next to them, we have to weigh that. But here we don't have that situation again. We don't have any great benefit to the county. There's no expansion of jobs. There's no expansion of any sort of revenues. We're just putting a new quarry, and keep that in mind. You're putting a new quarry in a highly dense residential area that's not really equipped to have an intense new quarry. This isn't in the middle of nowhere. This is right where existing houses are. So we've got to reverse that argument. It's not that the quarry's been here since the 50s. It's that putting a new quarry in an area where it's been residential for the last 20 some odd years, that's what we're doing here. And that's how we have to look at it. You know, I've been on both sides of this thing, representing applicants and certainly in opposing things, but you know, it's kind of a little bit of a misdirection on the berm, because as I put in my letter, the appellate court in the case that that Bolingbrook won against this applicant said, toward this end, the trial court found it transparently obvious that the scheme to have H&A pay outside contractors and then receive reimbursement from Mr. Zakharoff was conceived by Mr. Zakharoff to create the illusion that the site development activity, that is the removal of the berm, was nothing more than H&A continuing to do what it had done during the 9 years it owned the quarry property. So this berm was removed by the previous owner, but the buyer got the credit at closing. So this was a little bit of a side deal where you'll be the bad guy removing the thing. That's our appellate court concluded. You know, that's not my conclusion. That's the appellate court of the 3rd District concluded that it was a scheme conceived by the applicant here. Court found also numerous code violations. Bolingbrook, they were ineligible to get a business license in Bolingbrook due to the orchestrated scheme. This, you know, these are quotes out of the appellate court here. So when we have promises of we'll be good neighbors, when we have a past history, as far as the appellate court has to say, that we haven't been such good neighbors, you know, we need to take that into account. How can we make sure, if this were to go forward, how can we make sure that all the promises are kept? Because I know how it is. I know how it is on every level of government. We approve things, but enforcement many times lacks. I mean, it happens all the time. Unless somebody somehow, you know, reports something, or we don't have the human power to be out monitoring every piece of property. When we get enough complaints, we can follow up on it. But that's really not the main point. The main point you need to look at is this would represent putting a brand new quarry in a residential area. And this owner bought the property knowing what the current zoning is. He didn't buy it. Many times we have land deals. I'll buy the property once I get my approvals to expand the zoning. He didn't do that. He bought the property in its existing condition. So we can't even look at it as, well, you know, now he's a businessman. He needs to, you know, be able to make his property viable. He should have come to this board before he bought the property to expand the mining before he bought it. Not now I own it, now help me out here. That's not the way it works. It doesn't work that way. And many times people come to get their approvals to expand their operations before they actually put their money down. So this is coming after the fact, and perhaps maybe he had different ideas of what he was doing here. But I guess I need to conclude this here because I've gone on quite a bit, but we're strongly in opposition to this. We don't see any reason to put a brand new quarry in a very dense residential area. And believe me, these are some of the nicer homes in Plainfield. It's not that that should matter too much. You know, everyone's home is their castle, but this is a very nice neighborhoods here, and we do not want intensified mining activities at or near this property. So thank you for your time.
Thank you.
Good afternoon. Mary Alexander Basta, Mayor of the Village of Bolingbrook. Originally, I wasn't going to speak because I know that there's many residents here that would like to speak. However, we as elected officials are here to represent our residents. The residents, 200 and plus, have spoken in terms of emails. Their quality of life is going to be impacted and affected negatively if we were to allow this zoning change. We have to look after the interest of not just the area. Essington, I'm sorry, but Essington does not flood. The berm that was taken down under the understanding with the previous owner that the previous owner was going to put it back up. There was a lot of dead trees, and he was going to rebuild it to make it aesthetically more pleasing. That did not happen because of the sale. So to say that the berm, you know, everything was status quo, no, absolutely not. So we have to call it for what it is. This is an additional mining, as Mayor alluded to. It is going to impact not just the quality of life of those residents who live there currently, of which, as you can tell, many of them took time off from a vacation week to come and be here. They're very passionate about this. The quarry as it is currently does have an impact on their lives, and this would just increase that detrimentally. The Village of Bolingbrook and the board have filed formal objections along with the Village of Plainfield and the Plainfield School District. The roads, the damage to the roads that the increased traffic will bring in. Yes, a small portion of it is county road, but they have to go through municipal roads. That's going to be an impact on taxpayer dollars that has not been accounted for. So again, this is going to impact our residents. We are sworn to serve our residents. This will impact their quality of life, no doubt. Thank you.
Thank you.
Good morning.
Morning.
My name is Jack Fleury. I'm the president of the Lakelands Club Consolidated Homeowners Association. We are located at the corner of 135th and Essington Road in Plainfield, which is directly across the street from AZ Hard Rock, the subject property. Our association represents 85 homeowners, and we unanimously oppose this change in zoning, which is case ZC 24066. We have coexisted with the previous owner, H&H Stone, for nearly 18 years. And I'd like to refute the point that this man over here said that we didn't know it was there. The 150 trucks that come out of there on a daily basis goes right by the corner of our property, so we know exactly that. In discussions with county officials, we have been asked what we had expected when we built homes near the existing quarry. Back then, until 2022, the property was surrounded by a 25-foot berm with mature trees. We did not expect that the protecting berm would be cut in half, mature trees to be removed, and an expansion of the quarry to the north. And we certainly didn't expect underground mining and tunneling under Lily Cache Creek, which runs downstream directly behind some of our homes, within 25 feet in some cases. We've had dealings with AZ Hard Rock, Mr. Zakharoff and his attorneys, since the purchase of this property in 2022. He is the 100% sole owner of this property, and therefore the 100% sole beneficiary of this zone change, to the detriment of the thousands of Will County residents that live within a half mile of this property. After the purchase of the existing quarry, Mr. Zakharoff attempted to turn the property into a massive semi-truck parking lot with no license to do so. The Village of Bolingbrook sued, and the court found him to be deceptive in his scheme, which is the judge's own exact words. Throughout this process, safety and security measures were ignored, endangering the residents that live nearby. For example, there was no access to any water supply in case of fire which was highlighted by the Bolingbrook Fire Department. There is an existing court-ordered injunction preventing any truck parking. This was appealed by Mr. Zakharov and subsequently denied by the appellate court. This exemplifies why we have no confidence or trust that they even intend to underground mine in this area. A change in the industrial zone designated would allow highly undesirable industrial uses such as fueling, container storage, recycling activities, which would be right across the street from the Liberty Elementary School and many homes. The Liberty Elementary School is about, the front door of it is about 100 feet from this property, maybe a few more feet, close. We have spoken to many area residents. We have circulated a petition which has been signed by more than 450. And we have yet to find anyone who thinks it's that tunneling mine shafts 300 feet under the Lily Cache Creek, a waterway that feeds into lakes and supports our wildlife, is a good idea. Also, do we really think it's wise to allow open pits and shafts across the street from a school full of children? 30 years ago, mining might have been the best use of this land, but all that changed when homes and schools were built in close proximity. Your Will County analysts have recommended denial. Your Will County Zoning Committee unanimously voted to deny approval. The villages of Plainfield and Bolingbrook, which surround this property, and the Plainfield School District number 202 have all submitted formal opposition to this zone change. For those of you who are unfamiliar with this area, I urge you to drive north on Essington Road from 135th Street. You will immediately see that this zoning change makes no sense. The land needs to remain agricultural to buffer the ongoing quarry activity to the south and the east and to protect our Lily Cache Creek. We call on you to listen to your Will County residents and deny this zone change. Thank you for your attention.
Hello, everyone. My name is Margie Benucci, and I'm a village trustee in the village of Plainfield. And as was noted, we did send a letter, a unanimous letter from the board objecting to these zoning changes. There's a lot of issues here that you need to consider. But one of the things I take very seriously is the quality of life for the people that live there. When a person purchases their home, that's typically the biggest investment they're going to make. They move a certain place, they want it to be beautiful, they want a great school district for their children, they want a quality of life and good property values, and all those are very important. And I'm here basically for not just Plainfield, but Bolingbrook as well, and I have no jurisdiction anywhere over that, but I can tell you this, if you've taken a ride to the Lakelands area, you will see a beautiful development, a lot of wildlife, just a different type of place to live that you don't always find in a suburban area. The quality of life there will be greatly disturbed if you approve these zoning changes. I'm the first person that would be standing up for jobs any day of the week. But I can tell you, you need to balance, as we all know, and I'm not telling you your jobs because I've been where you are, so I can say this. You need to balance how that works for the residents and for the people that are trying to make different changes. Years ago, that might have been the place to be doing this. But for many years, this has just been a tranquil, beautiful, just gorgeous area. And not just because of the style of homes or the cost of a home, but just the general area if you drive through there. I'm also been a member of the school district in Plainfield for 22 years. And so we worked on a lot of those buildings. I built a lot of those schools from the technology side. And I can tell you that that's an important piece that those students also remain safe and undisturbed. And I'll share another point with you. When I first moved to Plainfield with my husband 29 years ago, we moved into an area of Spring Hill. Right behind us is Vulcan Quarry. It was near completion, but it was there. I chose to still buy the house there, but that was my choice, knowing what was there. But for you to have this beautiful place and then all of a sudden have that totally disturbed and disrupted by a group that's come in and that's already been noted that has been to court over some of these issues already because of different things that have gone on. I hope it takes a point that you take the time to pause and think, this is just not the best use for this property. And as far as an 18-foot berm, if I had to look out my door and look at a big hill that was just this giant berm with these trees on top, how is that an enhancement of the quality of life? It may block some truck activities or quarry or whatever's over there, but it's still really, would you really want to look at that? So thank you for your time. Thank you for listening, and have a good day.
Good morning. My name is Frank Arford. I live in the Lakelands Club neighborhood. My neighbor, Jack Fleury, explained where that is. By the way, my wife and I moved into our house in 2011, and we knew there was a quarry to the east, just across Essington Road, but the quarry was not in operation at that time. And there used to be a history of the company that owned the quarry at that time. That company's name was H&H Stone. And that history has since been taken down from the internet, but it explained that from approximately 2008 through 2013, the quarry closed because it could not operate profitably. And it wasn't until approximately in 2013 when they became aware of a new machine that could wash the sand that was produced in the process of limestone mining, that the quarry became profitable again and reopened in 2014. So I just want you to know that when we bought our house and moved in, the quarry was there and we knew it, but it was not operating, and no one that we could talk to understood whether or not the quarry was going to ever reopen. Anyway, last October, I attended the Will County Planning and Zoning Commission hearing on this same zoning change application that you're considering today. And I sent a summary of my observations and comments about that hearing to all of the Will County board members. And I just want to emphasize a couple of those comments today. At the October hearing, there was extensive discussion of this rezoning application. The applicant was represented by legal counsel and several experts, just as he is today. Many homeowners were present, even more than are present now. And some of those homeowners offered comments against the application. You've already heard that a local school superintendent, a Plainfield trustee that was Callie Larson, and a Plainfield board member that was Margie Benucci, who spoke before me. They also offered comments in opposition to the zoning change. While listening to the arguments, both for and against the application, I was impressed by the collective time and effort that had been committed to a debate of the requested change. It was comments made by the last two presenters in opposition to the application, that was Callie and Margie, that helped me focus on where the motivation for so many participants in that hearing came from. They both commented on the ongoing problem of past zoning approvals being in conflict with the community development that has occurred since those approvals were made. In this current case, the industrial zoning approval for the existing quarry was given over 50 years ago, and over those past 5 decades, both Plainfield and Bolingbrook have allowed residential and school development on the property just to the north and just to the west. The property is subject to the zoning change request. So no wonder there's friction and conflict, because you're being asked to allow the expansion of surface and underground mining on property literally across the street from many family homes and from schools. The many homeowners who came to the October hearing and the homeowners here today are convinced that the mining on the subject property will cause them harm. I understand that you have also received a copy of a petition signed by more than 400 homeowners who also believe that the expansion of mining to the subject property will cause them harm. So what to do about the kind of the conflict between the past and present? You can't revoke property ownership rights. You can't rescind previous zoning decisions. But I think you can avoid making the conflict worse by voting to deny the present zoning change request and the related permits. So I'm asking you to deny that approval. And I want to thank you for your time and for listening.
Thank you.
Good morning, Susan Prock. I'm a resident of Americana Estates in the village of Bolingbrook, and thank you for the wonderful comments. I learned a little bit there that might explain why during the period of time up until 2013, we didn't feel much of the blast. I would only like to add that we respectfully request that you deny this request, which would add value to the land of one and diminish the value of the real estate owned by hundreds that surround this site. I do respect and value the opinion that was offered by the Village of Plainfield's mayor and the Village of Bolingbrook's mayor that this should be evaluated as if you were being asked today to approve a quarry surrounded by residential and schools, soft uses, as if it were a new application, because that in fact is what it is. To expand what was there would have affected, perhaps in it negatively, all of our collective decision to choose to live where we live. It would be like putting an undesirable use right next to your home. Had you known about the undesirable use, you may have chosen not to purchase the home, or certainly not have paid the same price. So again, I respectfully request you deny adding value to the land of one at the expense of everyone else. And I agree with the village. Essington does not flood, does not flood. And someday that interchange is going to be expanded on another note. And what are you going to do with semi-truck trailers then? What's happening today? I think we as a resident, I bought in 06. I've been here a long time. I used to live in Spring Hill. I used to live right backed up to the quarry. Had to replace all the windows because it does have an effect. I'm further away today. When you blast, we're like a little earthquake. You don't hear it as much as you feel the ripple underneath the earth. And we tolerate it because we knew it was there in its current condition, in its current size, with whatever duration is left, not with the expansion of what they are proposing. Thank you again.
Thank you.
Good afternoon. My name is Mike Boyd. I'm here with my wife, Deborah, and we reside in Americana Estates. I first want to thank Mayor Mary for your continued advocacy of your residents and constituents in Bolingbrook. We really appreciate you. We know that you have been with us through every step of the way with this process, and it's something that we really value. I want to just try and make my remarks really sort of respectful, direct, and succinct. So I don't plan to be up here a long time. The first thing is I would appeal to the board to prioritize the residents over profits. Simple as that. That's my request. I think that, and in fact, I would encourage everyone in the room, those who have spoken in defense of this or and each of the distinguished board members to just look at the back of the room. We are the people that live in these properties. Everyone back there is against this. And it's not because we don't believe in entrepreneurship. It's not because we don't believe in capitalism. It's because we don't want our places destroyed. We don't want our environment degraded. We love our neighborhoods. And so we want it to remain as it is today, not the way someone else may see it that doesn't live there, that didn't do the things that we had to do for some of us, move into our dream homes. And so we don't want our dream homes degraded because someone has greater dreams for greater finance. Let them figure it out somewhere else without degrading our properties. And so I think just sort of one final comment, you know, I don't know this individual. I don't have anything against this person. I'm not an individual that dislikes people that I don't know. That's, you know, but because you're encroaching on my lifestyle, you're encroaching on our property, you're encroaching on our neighborhood, I'm going to resist that. And I think that that's what you're seeing today. I do appreciate the effort that was put forth in the defense, but because in some ways it sounded so sort of benign that it almost seemed like it was doing us a favor to have this happen. But I just don't see it that way. I honestly don't. A favor is letting us continue to live our lives the way we do and figure out another place that you wouldn't have to cause such disruption. So, you know, we're totally against this. I think you can see that. I think many more people would have been here had we had more time to plan for it. And as it relates to my final couple of comments, you know, there's water on Essington. I live a block away from there. I've never seen it. See a lot of deer running around there, and I like to see them still there. And the blasting would be at such a decibel level, we wouldn't even hear it. It would be above our children's voices. I'd rather hear the kids. So just totally against it. And thank you guys for listening and appreciate the time to be here. Thanks.
Hello, I'm Meredith Giansos. I'm also a resident of Americana Estates, and I spoke here back in October as well. On October 1st, I invited the applicant and their counsel to visit our neighborhood and my home personally to experience the blasting firsthand. The statement from council today saying that they have been a good neighbor and have reached out to us to invite us for a tour is false. While that may have been a gesture that they've offered in the past, no new effort to engage with our community has been made since October 1st. If they wanted us to visit their site or to engage in a healthy dialogue and educate the citizens about their intentions, then they should have sent formal letters to our residents or reached to our HOA directly, which is very accessible. Our HOA and my fellow neighbors have not received one outreach of good faith or a visit from the applicant's team. While you have received over 200 emails so far, I can assure you that many more are coming. Our neighbors were shocked to see that this meeting that was initially planned for January 14th was changed with little notice. My fellow neighbors were ready to attend on January 14th in very large numbers. And given the holiday week, a fraction of my neighbors are here today, many of them sitting there and many of our fellow neighbors in other communities. We have 117 home sites in our neighborhood, and every single resident in that neighborhood is against this request. This is not a rush to judgment. We live there every single day, and they do not. We really need you to hear us. Come experience it yourself. come see the damage that we've already experienced in our homes. It is true. We have had neighbors have things come crashing down, foundation issues, window issues. You name it, it has already happened with the blasting that is already far enough away. We kindly request that you consider our neighbors, our investments, the beautiful community that we have, and more importantly, all of the children who attend schools all up and down Essington, who participate in activities outside, who go running with their cross-country and track teams in the same area. This just is not a new idea that should be considered at this time. Thank you.
Thank you. Any lights on here? I don't see any. I have a couple more questions for specifically maybe an engineer or somebody that can talk about the blasting.
We'll bring them up based on the question.
Okay, so there's no plan to do any above ground mining to the west of Lily Cache Creek.
That's correct.
So once you guys go, assuming you were given permission to do this underground, the blasting that occurs, can you hear it from across the street or above ground, or what kind of decibels does that create if it's an underground blast?
I'll allow the engineer to answer that question.
Hi,
State your name.
Chuck Palmcook.
Chuck.
Been an engineer doing this for 27 years now. So could you restate your question for me, please?
Just talk about underground blasting. If you're not down in the mine, but you're at least say 200 feet away, what kind of decibels are we looking at? What kind of shaking, or can you even tell it happens at all?
It's very tough. Surface mining is way different than underground mining. Underground mining, you use much smaller charges, about 20% of what you use on the surface. It just doesn't carry. Air, you can't hear it underground because you have hundreds of feet of material on you, 100 feet plus of material. The only place that energy can go is out the portals into the existing mine. They're not going to hear it over there. I'm very confident of that. With much smaller charges, there is going to be much less than what they think they are. It's, 20% of what we're doing on the surface. So can I say you'll absolutely never hear it? No, you're not going to feel it, I never say never, but it's not going to be this doom and gloom that they're saying, that shaking houses, wrecking houses. There are federal regulations that we abide by right now. Will County has regulations that are half of what the state regulations are, and we easily abide by them. We're going to continue to do that as we expand. If we get the permission to go underground, we will continue to do that. That's not going to be an issue. We will stay within the county limits to make sure no damage is done to property.
Okay, thank you. And then the distance, so there's 200 foot, the plan is to have a 200-foot barrier, an 18-foot tall berm from the property line to where any work can be done. How far is it from that berm to Lily Cache Creek going to the east? Like before it does that turn to the east?
Mr. Shamsi, do you want to, Mr. Shamsi, could you address that question, the distances? Because Lily Cache Creek is circuitous. So the distance from the property line and the 200-foot setback to your.
State your name and company.
Okay. Michael Shamsi, Landmark Engineering Group. Okay.
Michael.
What was the question again?
Yeah, I'm just wondering how far it is from the backyards of those homes on the west side there of, that's Essington, right? To the creek.
On the west side to the creek?
Yeah.
I'd probably estimate 1,000 feet at least.
Yeah, that's what I was thinking too. There's 200-foot berm. On the last slide you had, Margie, you had highlighted 200 feet. So if I
Right.
multiplied that to the creek,
We're-
you're looking at least 800 at its closest point, and at the top, it's probably
More at the top,
quite a bit of distance.
quite a bit of distance.
All right. And then any of the above ground mining is to the east of Lily Cache Creek. But, so we're saying it's 1,000 feet or so from Essington Road.
From the above ground mining, I'd say over 1,000 feet just to Essington.
Thank you.
Thanks.
Any questions from the committee before we vote here?
I just have one.
Member Ogalla.
Okay, so when I'm looking at this picture here, the northwest corner, the top of the property, what will that look like when they're doing mining? What's the plan with that? Will it look somewhat similar to this? Will it be all taken up? It's green right now.
In terms of like what the ultimate site plan is going to look like? Yes, so a site plan question.
I think that's Mr. Shamsi again, describe the flood controls
Yeah.
system that's.
Yeah, so we're using the west side of Willie Cache Creek for detention basin. And so there'll be no surface mining on that side. And so right now it's green space, but it's going to be green space, but at a lower elevation to store stormwater. And so there'll be no surface activity on that side of Lily Cache Creek.
The upper right corners, which is where it's kind of circular there.
Where the trees are in the upper right corner? I don't believe we have any real plans for that corner. Right in there?
Yep.
Because, with the buffer and the berm there and the creek coming through. So it'll be a minimal impact in that corner.
How far away will above ground mining take place from that corner?
A minimum 200 feet.
So you'd go right up to the berm.
Well, the berm's 113 feet wide. So it's actually, 80 something feet, 87 feet from the toe of the berm on the quarry side.
Okay, thank you.
Thank you.
Oh, we have a question from Board Member Freeman.
Yeah, thank you. The application called for concrete/asphalt production. Where would that be occurring?
We haven't determined that yet on the site, but it'll be probably close to, there's a mining plan that we'll need to submit to the county and to the state, but it'll probably be on the eastern edge of our property, as that's where the ingress and egress will come from.
And is it concrete or is it asphalt production?
Both.
So-
There's a concrete batch plant south of 135th Street that's existing, that's called Welsh Brothers. And they have told us they're not intend to move. It's a large structure you can see from the highway. And there's a restriction on the contractual restriction to put another concrete batch plant on the 260-acre existing AZ Hard Rock Quarry. So this would let another competition, another vendor, another concrete mixing operation and asphalt.
And the smell associated with that, what's it like?
Well, we buffering from the neighbors. The smell would be pursuant to Illinois EPA and a Ross discharge permit. The modern plants today are very mild in terms of their output because of environmental restrictions.
Okay, thank you.
Margarita, I have a question. Not from this picture, but to the right of what I'm looking at, the curve there to the right. Yep. There's a property that's not part of this property. What's going on that property there?
So the area over here, sorry, I don't have a better image. It is within the village of Bolingbrook. It does appear to be platted, like a future residential subdivision would be desired to go there. But the streets are not dedicated yet.
Right. It doesn't look like it's not been developed at all, right?
Correct.
Okay, thank you.
Okay.
Since there was just a couple of comments by Chairman Pretzel about the distance, I just want the members of the committee to recognize that the county standard is 6 feet, and we're going 3 times that to the for the purposes of the berm, of the height of the berm, to 18 feet. There seemed to be some confusion by Village President Argadelis. He was asking about, if it was going to be 18 feet wide. I think we did some quick math and we were thinking based on 18 feet, it's 132 feet or something of that nature. So we're actually 3 times the county standard.
Thank you. Okay, and before we vote, I just want to address one thing. I know several were disappointed in this board changing the date of this meeting. And I just wanted, that has nothing to do with the applicant or our staff. Every 2 years after the election, we go through a change of our committee structure, and that also includes changing some of the dates. The current chairman of the county board selected Thursdays for these meetings instead of Tuesdays. We didn't change it to leave anybody out or take notice away from you. And I sincerely apologize. We really do want you here for these meetings and give you the opportunity to speak. It just so happens that this was right after our reorganization. So these meetings will always be the first Thursday of the month going forward for the next 2 years. So, okay, I think we're ready to call the, Dawn?
Yes, so for roll call, I would like to acknowledge Sherry Williams is on the committee today. She will sit and her voice will be recognized.
Thank you. Oh, and one more thing. We are going to take 4 different votes here. The first one is on the map amendment, and then we have 3 special use permit applications.
Correct.
Go ahead.
So we need a motion for map amendment from A1 to I3, applies to 90.096 acres.
Motion. We have a second.
Okay, Sherry Williams. Denise Winfrey. Judy Ogala.
Yes.
Herbert Brooks.
Mr. Chairman, if I may, before I vote, Don, hold the pen for a minute. I think Castle Law and operators and the engineers made a very good argument why I should vote yes. But Mr. Chairman, I think the mayor, the trustee, and the residents put up a very good argument why I should vote no. And so it's a very tough decision. And I think everybody up here knows that. And in light of that, Dawn, I am a no.
And Chairman Frankie Pretzel.
Yes.
So 3-2, it passes.
Okay. Next, I'm looking for a motion and a second. This is for a special use permit for mining, quarrying with blasting, or other use of explosives.
I'll make that motion.
I'm sorry? And we have a second. Okay.
Sherry Williams. Denise Winfrey. Judy Ogala.
Yes.
Herbert Brooks. And Chairman Frankie Pretzel.
Yes.
3-2.
Next, I'm looking for a motion and a second for a special use permit for concrete and asphalt mixing.
I'll make that motion.
We have a motion. We have a second.
Sherry Williams. Denise Winfrey. Judy Ogala.
Yes.
Herbert Brooks.
No.
And Chairman Frankie Pretzel.
Yes.
3-2 pass.
Last, I'm looking for a motion and a second for a special use permit for clean construction or demolition debris fill operations.
I'll make that motion.
We have a motion and a second. Go ahead, Don.
Sherry Williams. Denise Winfrey. Judy Ogala.
Yes.
Herbert Brooks. And Chairman Frankie Pretzel.
Yes.
3-2 pass.
Okay, thanks. And for those of you paying attention to this case, the full board will vote on this on the 3rd Thursday of the month, which is January, I think 16th. January 16th, right here, County Office Building, 9:30 a.m.
because of the objections they have to have.
And because of.
9 a.m. is the meeting.
I'm sorry, we changed it tonight. Because of the legal objections from both the Village of Plainfield and Bolingbrook, they will have to have 2/3 support from the board to be approved. Thank you. Moving on to. Oh,
If I may, it's just the map amendment that the legal objection would apply to. So the special uses would be simple majority.
thanks for the clarification on that. Next on the agenda, ordinance amending the Will County, Illinois zoning ordinance as approved, as amended for zoning case ZC 24092. Scope Investments LLC, owner of record, and Vincent Tessitore of Castle Law, attorney, requesting a map amendment from A1 to I2 in Wilmington Township, County Board District Number 3. Looking for a motion and a second, please.
Motion O'Gala. Second.
We have a motion and a second. I apologize. This is at 25109 West Lorenzo Road in Wilmington. We have a motion and a second. Margie, do you want to fill in the blanks on this one?
Certainly. So this zoning case, you may recall the property immediately to the east of the property is Save Trucking. It came forward a few years ago requesting a truck terminal. It does existing, has access to Lorenzo Road to the north. However, the BNSF rail line, which is about 500 feet to the east of this company, is constructing an overpass, and part of the construction requirements is removing the existing entranceway to Say Trucking. So the railroad deeded over about 1.9 acres of the property immediately to the west of Say Trucking for new access. Since the property is zoned A1 and it's only 1.9 acres, it doesn't meet A1 standards. So in terms of constructing a driveway to get access, they cannot get permits. They are requesting to rezone to the I2 zoning district, basically to establish a new access way and to allow the county to permit that driveway and access. This area is within the Joliet Arsenal Enterprise Zone, or at least it's adjacent to it. It's within the Wilmington Freight Cluster, which is part of the Will County Community Freight Mobility Plan. This area is foreseen to become a very industrial area. So in terms of the rezoning request, it's within character, it's within the trends of development, and there's existing industrial in this area. I'm happy to answer any questions.
Thank you. Is there anyone here from the public to speak on this one? I see the applicant and their attorney's team are here. Is there anyone else that wanted to speak on this one? Okay, do you guys need to hear from? Okay, I think we're ready to vote on this.
Map amendment A1 to I2. Could I get us, are we going with the first motion? Okay.
Yes, please.
All right. Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Chairman Frankie Pretzel.
Yes.
Passes.
Okay, thank you. Next on the agenda, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case 24082. Cosmopolitan Bank and Trust, owner of record Keegan Wilson of Wilson Industrial Sales Company, Inc., doing business as Wilson Chemical Solutions, agent Vincent Tessitore of Castle Law, attorney, requesting a map amendment from A1 to I2, a special use permit for a truck terminal in Wilmington Township, commonly known as vacant property on West Lorenzo Road, Wilmington, Illinois, County Board District Number 1. I need a motion and a second, please.
I'll make that motion.
Second. We have a motion and a second. Is there anybody here that wanted to speak about this zoning case, other than I see the attorney's team is here? Anybody here to speak on this zoning case? Okay, do you guys want to hear from the attorney on this? Any questions? Okay, I think we're ready to vote on this one, Dawn.
Map amendment A1 to I2. Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Frankie Pretzel.
Yes. Next, we need to vote on the special use permit for the same case.
Special use permit for truck terminal. Same motions.
Well, can we get a motion and a second on that one? We have motion second. How about a previous rule?
So Gala.
Previous second, all in favor?
Aye.
Any opposed? Motion carries.
Thank you. Special use permit for a truck terminal, Sherry Williams.
We're good on this one, Dawn. We had
Oh, okay, that's right.
it was unanimous. Number 4, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case 24077. Nick and Paulina Peleothodoros, owner of record, requesting a special use permit for rural events in Homer Township, commonly known as 14151 West Chicago Bloomington Trail, Homer Glen, Illinois, County Board District Number 4. I need a motion and a second, please.
Motion O'Gala.
We have a motion and a second, and then Kelly, do you want to give us more information on this one?
Yeah, so the applicant is requesting a special use permit for rural events. They're looking to host weddings, baby showers, and birthday parties. They plan on using a temporary tent for these events and proposing 146 parking spaces and approximately 50 to 150 guests. They are looking to have the events from 10 a.m. to 10 p.m. Additionally, the Village of New Lenox submitted an objection letter regarding the special use permit. Their concerns include the location of the parking lot, temporary structures, noise from the events, hours of operation, and traffic impacts. Additionally, they noted that the property is planned as a residential property in their comprehensive plan, which conflicts with the proposed agriculture use. Since the Planning and Zoning Commission meeting, staff also received a letter of objection from the Plute Home Company, which is the contract purchaser for the parcel to the south. The concerns are similar to the Village of New Lenox. An additional concern is the gravel parking lot. A copy of this letter was included as a memo. The Village of New Lenox and Plute Home Company had suggested conditions if the special use permit is approved. This includes limiting the hours of operation to no later than 8 p.m., capping the guest capacity at 50, and requiring landscape buffer along the south and east property lines. Planning and Zoning voted 7-0, recommending approval for the special use permit, and staff is recommending approval of the special use permit with 5 conditions. I can answer questions, but the applicant is also here if you have questions for them.
Thank you very much. I will invite the applicant down to the microphone if you'd like. While we're waiting for that, do we have any questions from this committee to staff?
No.
Okay. Hi, welcome.
Good morning.
Please
Good
introduce
afternoon.
yourself. Please introduce yourself and good afternoon to you.
My name is Paulina Peleothodoros. And me and my husband are requesting the special use permit. I do have just a short letter, or should I read that?
Yeah, please.
Okay. So 2 years ago, we discovered our current property. Owning a home for my horses has been a dream of mine since I was 14 when my dad bought me my first horse. Although the property was in rough condition after being vacant for 2 years, my husband and I took the leap of faith, believing this was the ideal place to raise our family and share a little piece of this lifestyle with others that may not be able to have this as their everyday. In recent years, many young families have chosen to swap traditional homes for more spacious living with ample land, and we felt compelled to do the same. We invested everything we had into this property, determined to make it a home that reflects our values and aspirations, and we continue to envision improvements for our future here. We recognize how fortunate we are to embrace this lifestyle, one that many people dream of but struggle to attain. This realization fuels our desire to share our experiences with our community. After all, it's not every day that people get to see horses up close or enjoy a unique setting for traditional events. Our vision is simple: to provide a welcoming space that brings together friends, family, animals, and the beauty of the outdoors. Some events we hope to host are children's birthday parties, bridal showers, baby showers, and smaller wedding ceremonies and receptions. We want to remain true to the reasons that drew us here: the space to keep our horses, the dark skies filled with stars, and the peace that comes with it. This sparked the idea of creating a smaller scale venue, and we have dedicated the last 2 years from preparing our property for this chapter. I do want to emphasize the drastic contrast between what my husband and I are proposing and the scale of Pulte's Homes development. They are purchasing over 200 acres to build hundreds of homes, while we have a modest 5-acre property that we work hard to turn into something special for our family and our community. On the back end of our small property, 8 homes are being planned up right against us with no consideration of any kind or buffer or space. It's not exactly fair that we're retreating as the problem for wanting to create something unique and beneficial for the town, a venue that preserves the charm of our property and serves the community, while a massive development imposes far greater impacts. We are simply asking for the opportunity to use our land responsibly and in harmony with our neighbors. We did prepare a response to the memo that Pulte Homes submitted on, I believe that was the 27th of December. That should be with you, but I do have my responses here as well. Should I read those?
If you'd like, this is.
Oh, okay. Okay. So some of the responses or concerns that Pulte raised was one, inconsistencies with Village of New Lenox plan. The Village of New Lenox expressed concerns over our request for a special use permit, but it's important to note that we are located in an agriculture zone. Our property and the surrounding area have always been agricultural and rural, and we're committed to maintaining that character in our venue. The venue itself will be small, a family business, not a large commercial operation, and it will provide a unique opportunity to add value to the community without altering the fundamental agriculture character of the area. Additionally, we believe it is worth noting that we initially bought this property over 2 years ago, specifically due to its agricultural zoning and location, and we invested significant resources to restore and improve this land. It is troubling to us that a large development from Pulte is now being proposed to encroach on this rural space with little regard for the long-standing agricultural heritage we worked so hard to protect. Another issue, I guess, concern was noise and hours of operation. We fully understand the concerns regarding noise, and we are committed to adhering to noise restrictions. We would like to confirm that all events will conclude by 10 p.m. Additionally, we want to ensure that amplified music and other noise sources are kept at levels that are in compliance with the county's ordinances. We will also ensure that our venue is not a disruptive force in the community. We do not believe a 10 p.m. curfew on our events would create significant noise disruptions, especially when compared to the residential traffic and increased activity that Pulte's development will introduce to the area. Pulte's proposed project will result in substantial increases in light pollution, traffic noise, and congestion, which will undoubtedly affect us and other residents. But we have not made those issues our primary concern. Another issue is proximity of residential properties. While we are aware of the residential properties that currently exist near our property, it's important to know that our venue is located in an agriculture area. We are not located within a residential zone. The development proposed by Pulte, which will bring 490 homes into the area, will create significant disruptions for everyone in the area, including us. These homes will be in direct proximity to our venue and have a far greater impact on the quality of life in the neighborhood than our rural venue ever will. Additionally, the 8 proposed homes that will touch the back of our property are part of phase 3 as outlined in Pulte's development plan, which is noted not to begin until at least 2032, meaning at the very minimum, we would have 7 years before any homes are being built. And the assumption is that they would not be ready and available for purchase until at least 1 year after. Transferability of special use permit. We understand that Pulte has concerns about the transferability of our special use permit. However, we believe that the special use permit should remain transferable as we intend to continue using the property for agricultural purposes, hosting rural events. If there are any changes in ownership, we are committed to working with the county to ensure the property continues to adhere to the agricultural nature of the area. We do not believe that a blanket requirement for new owners to submit a new plan should be a barrier. It just adds unnecessary red tape for family-run businesses like ours. Exceedance of accessory structure limits. Regarding the proposed 7,500 square foot event tent, we understand the current concerns about the accessory structure size exceeding the limit of 3,000 square feet in the A2 district. Our other structures are solely for purposes for animal confinement and do not count toward our total square foot allowance. Since we are not using existing buildings, we believe that the size of our tent is a reasonable necessity for events, and we are willing to work with the county to ensure compliance with all necessary zoning codes. Additionally, the tent would not be a permanent structure, and 7,500 square feet is the largest tent size that would be in use. There are many instances where the tent could be smaller or there would be no tent at all depending on the event. And finally, concerns regarding gravel parking lots and screening. We understand that parking lots require maintenance and are committed to ensuring that property landscaping will be implemented to minimize any negative visual or noise effect. The parking lot will serve as a dry lot for our horses when not in use, and we'll also ensure that it is properly delineated and free of hazards. We will submit a formal landscape plan and ensure that it is in compliance with all county standards. We're also open to discussing options for paving the parking lot if that would be a condition for approval, although we believe that a well-maintained gravel is a reasonable choice for the rural nature of the area. Lastly, we expect to be lived through all the construction while Pulte begins infrastructure plans and the building of homes, which will surely cause dust and pollution to our property. Based on the proposal submitted by Pulte, this would be a minimum of a 7-year project. We're not only concerned for ourselves or other neighboring properties, but also the animals we house, as they cannot escape the construction debris and pollution. This will cause much more pollution and dust than a gravel lot, that needs maintenance every couple years. Additionally, even if we do not use the event area for events, we take pride in our home and we would make improvements as necessary. In closing, we strongly believe that our venue will be a positive addition to the area, and we're committed to making it work in harmony with the rural nature of the property. We're a small family-owned business that has invested heavily in this property to restore its agricultural roots. We ask the board to consider the impact of Pulse's development on the rural character of the area, as well as the steps we're already taking to minimize the impact of our venue. We hope that the board will approve our special use permit with appropriate conditions to ensure that we can continue to operate in a way that benefits the community. Thank you for your consideration.
Thank you. What is your plan for the space? Weddings? Is this more for like birthday parties?
Yes, so it's kind of a combination. So children's birthday parties, baby showers, bridal showers, and then smaller wedding ceremonies and receptions. By smaller, I mean no more than 150 people. Some obviously could be less than that.
What days of the week would this be available for?
We're typically just focusing on weekends, so Friday night, Saturday, and Sunday.
Okay.
And yeah, I see that you want 146 parking spots. Is that what the county is telling you need, or is that you think you need that many spots?
My husband was actually speaking to the county, so I'm going to let him answer that.
So, I mean, this is very new to us. So we just looked at the space that we have, and I'm not sure how many spaces we need, but this is just what I came up with that we have available. So I figured I come up with a number. I worked with the company to create a site plan, and we came up with that many spaces. So
yeah, the reason it matters is when people see the number of spots, they automatically assume they're always going to be full, and if they have any cars going in and out. And with gravel parking lot, it causes gravel on the. So that's why I asked.
Okay, yeah, and it can be less. I mean, if you looked at the site plan map, we can adjust different areas for parking to take place, but it's a farm, it's a little barn, and things are movable too. Nothing's permanent there, and we don't want to make anything permanent. We want to do that tent that you mentioned, and yeah.
Got it. Okay.
Any other questions?
Did you have a question?
I do.
Member Brooks?
First of all, Paulina, you have to come back and read that letter all over again, slower. You might have asked my question, but it went so fast. What type of project events are you going to be having in this tent? Children.
Sorry, come back.
Yeah, I mean, I can answer that too. It's just children's birthday parties.
Just children.
Yeah, like it's going to be all horse rural themed parties, right? We're already that. That's what the area is. Our backdrops are all that. So we want to make that to be, we're going to market that, and we want people to come for those reasons. It's not like your typical.
Right.
It's not Chuck E. Cheese, It's we want it all to be like horse themed and more geared towards like better weather days, like summertime, spring, early fall.
No adults though. Liquor license, you don't need none of that. So
yeah, we would need that for the larger events.
For the children?
So not for the children.
Oh, okay.
No.
Thank you.
Yeah.
Thank you.
There's weddings.
Weddings
I
and
heard
baby
weddings.
showers.
Okay.
The big tent in the 10 o'clock hours would probably be
Okay.
over.
And I know you said it, but I was trying to wait till you got through. Okay. Thank you, Mr. Chairman. Thank you.
Sure.
Say something.
Go ahead.
I just wanted to say that in Crete, we have a property similar to this, where they had a house with a pole barn on it, and they took it and made it into a rural events, and they do weddings and parties like that, probably not children's parties, but it's worked really nicely. It's an added benefit to the community because you can do something like that locally rather than having to travel further to have a party like that outside. And doing something like this maintains rural character, which I support. I live on a farm, so I love that fact. And rather than putting hundreds of houses on, or I don't know how many houses you can get on 5 acres, depends on your plan. But I like that, and I like the fact that it would be transferable, that you guys as a young couple probably keep it for a long time, but at some point you might want to relocate. And then another young couple possibly could come in and continue on with that. And you maintain that 5 acres as basically open space. So I like this project. Thank you.
Yeah. And can I add to that? And around the property, there's a lot of available land, not for sale, but if it ever becomes available, our goal is to purchase it to keep the look, to keep that open space look, to keep that rural look. You know, it's unfortunate, but I understand why our neighbor behind us is selling. She's been there a long time, and it's, you know, life goes on, and it is what it is. So we're just trying to work with both parties and work with everyone, make the town happy. There's weddings that take place for this type of event way further away. I know people local go to those parties. Why not bring it closer into Will County, keep the business here? It's not just going to stimulate business for us. It's going to stimulate business for the surrounding area, New Lenox, Lockport, Homer. I mean, the list goes on, but we want to do it in a respectable way. So.
Okay, and then it was addressed by Paulina. The Village of New Lenox has objected to this, and I see they're coming to speak next, but some of their concessions, I guess, if we were going to approve this, was could you change the hours to maybe 8 p.m.? Could you limit it to less people, maybe 50? And, you know, the parking lot being gravel, you already mentioned you'd maybe be willing to pave it, but would those things be something that would?
So the 50 people limit, no, just because we do realize that every family is a little bit different. Like my family's small, but my husband is Greek and there's like 50 of them just in his immediate family. So it'd be really difficult to have such a small cap, like it'd really limit what we're able to do. So I don't think that we'd be able to agree to 50 people. The paving we're open to, but we prefer the gravel just because it kind of adheres to the rural kind of setting versus a paved driveway or a paved parking, I should say. The 10 p.m. also, I've never been to a wedding that is ending at 8. So that would also be pretty difficult because that would eliminate that entire potential for us. Nobody wants to come to a wedding and leave at 8 o'clock. We think that 10 is pretty reasonable. A lot of other venues are open till 11 or even midnight in the area. So we do want to, you know, obviously be respectable to the potential residents that are coming into those homes, but we think that 10 o'clock is fair.
Okay. Thank you.
Thank you.
Any other questions for the applicant? Okay. I see the Village of New Lenox is here. Okay. Please introduce yourself.
Yes. Hi, my name is Robin Ellis. I'm the Assistant Village Administrator and Community Development Director for the Village of New Lenox. It's weird to be on this side of things. And I'm not going to reiterate all of our concerns because they've been discussed and rebutted, but our main concerns are, and I think the Mayor of Plainfield addressed this in his comments on the first issue, is the enforceability. You know, if we put hours of operation, if we try to enforce noise, we know it's a very large county. The Sheriff's Department is very taxed. You know, our long-term concern is the enforceability. You know, we believe in, you know, the good intentions that the petitioners have, but we're concerned with the transferability because if it does transfer with the land, we don't know what the next people may do. You know, unlike Board Member Gala's experience, we have another location in the unincorporated area of New Lenox where it is a constant noise issue. And getting the county to address it has not been high on their priorities. So, you know, our concerns are the noise, the hours, you know, with the other issue with the gravel is it's hard to, you can't really stripe parking spaces. So while their plan may show 146, people park haphazardly. You know, our emergency vehicles able to get through? Is there logical traffic patterns, or are people parking haphazardly to then they have to park on the street because they cannot all fit on the site? So that is why our Plan Commission and our Village Board all unanimously voted to object to this request. So I thank the committee for your attention today and your consideration of our concerns.
Thank you for being here. Welcome.
Good afternoon. I'm Caitlin Chuck from the law firm Rosenova & Whitaker, and I'm here on behalf of Pulte Homes. I just wanted to echo everything that Robin just said. We're not necessarily opposed to the project, but again, we just want to make sure that the site plan is appropriate and can work with what we're looking for. As Robin mentioned, our biggest concern is noise. The staff report before the Plan Commission meeting mentioned that they would just have to adhere to code. Code is a little confusing in that sense. There's certain restrictions for noise as it relates to residential properties and then commercial properties. This property is zoned A2. Under the A2 zoning designation, it mentions A2 is agricultural/residential. So my interpretation of that is that this is an agricultural/residential district. So my question for staff was, do they have to adhere to the residential noise restrictions? And if we can place those restrictions into the ordinance in order to understand exactly what they would have to adhere to, I think that'd be super helpful. Again, when this was before the Planning and Zoning Commission meeting, there was no mention that the property was being annexed to New Lenox. It was annexed, the property was approved, the annexation was approved December 16th. And with that, now these homes are coming in. Different conditions than what were proposed or expressed at the Planning and Zoning Commission meeting. So again, I'm not going to reiterate everything that Robin spoke on. Again, we just want to work with the applicant, and we want to make sure that the site plan is not a detriment to adjacent residences, because as you see, a special use permit, you're required to answer certain standards, and as it is currently proposed, there would be a detriment on these adjacent properties. So again, the gravel parking lot creates a lot of dust. In a lot of other places, there are screening requirements where there's a parking lot immediately adjacent to residences or a residential district. So we just want to make sure these things are in place in order to make sure that both parties can live harmoniously. So those are all my comments. Thank you so much.
Thank you. Appreciate you being here. So I understand this, there's a whole new subdivision going in. And when you look at a new home, it's 1, 2 in the afternoon. You buy the home for a few $100,000 and you don't realize that every Saturday night there's going to be music playing until 10 p.m., right? It's the first time. So I do understand wanting to have some strict parameters around what's allowed. I guess my question for staff is, with special use permit, can we include some of those parameters? And do we as a committee want to do that and just make sure that we have the right language in there that says, this is the.
I'd be willing for them
Please,
to.
microphone.
I don't want to unnecessarily restrict the new business coming in. The barrier of landscaping between the back of their property and the development would probably muffle a lot of the noise if there's some trees, bushes, something like that. I think 10 o'clock is perfectly reasonable. I don't know how they would do a wedding cutting off before then. So that just seems reasonable to me. And it's a 5-acre property. I think there's enough space for both things.
Okay. And that is in the permit application that 10 o'clock would be a hard stop.
It's not added as a condition, but it was included on the application. So if you are looking to add an hours of operation condition, that would need to be added. It was not included in the staff report.
The other question is, the housing development is what was annexed to New Lenox, not their property, correct?
That's correct.
Okay.
So I will go ahead and address that one issue. And since the applicant had asked for 10 a.m. to 10 p.m. and for a wedding, it is reasonable. I would like to make a motion to add a condition that the hours would be limited to 10 a.m. to 10 p.m. Friday, Saturday, and Sunday.
Motion and a second. Please call the roll on the amendment.
Amendment adding condition number 6. Sherry Williams. Denise Winfrey. Judy Ogala.
Yes.
Herbert Brooks. And Chairman Frankie Pretzel.
I'm a yes on that. Okay, there were some other concerns. We mentioned landscaping buffers or distance with parking. Any thoughts on the committee? Yeah, wanting to make any other conditions?
I'm first. That's it.
Member Brooks.
Now with gravel, there's ways to mitigate some of the problem with dust, watering. I mean, not very expensive ways. So, Mr. Chairman, is that a special use issue that it's not blacktop? Would that be a hindrance? Because you can handle gravel many different ways and stay within the parameter of what you're asking.
I don't live in the country, so I'm learning a lot of things as chairman of this committee.
Come on out, I live in it, come on.
With fencing and paved lots, I like to see asphalt, but out in the country, I understand that they don't, and it does change the whole look. So I'm not prepared to make a comment on that one.
So I live in the country and I work for a rural road district. We have a lot of gravel roads. And I would think that if this was my property and I was developing it to do what you guys want to do, there are certain times of the year when it's very dry. And so if they're going to have people coming out to their property for these parties, I would think that they would spray something on it to keep the dust down, because one, they don't want the dust on their, clients' cars and everything. Plus, they don't want that dust themselves. Although kicking up dust in a parking lot is going to be pretty minimal because you're driving pretty slow. You go there, you park, and you're done. It's not like a road where people are going all day long. And out in the country, they're never traveling slower than 45 miles an hour ever that I know of. So I don't think that the gravel is a bad thing. And it does kind of go with more the aesthetics of the property they're proposing.
Okay, and we talked about landscape berming or buffering.
Just one more thing on that, because if they're building a development there, as a part of their development, they can build a fence along the back of that. The developer, can build a fence screening their property from this business. So I don't see where they need to take an extra burden.
All right, any other questions? Anyone else here to speak on this case? Okay, Dawn, I think we're ready to vote.
Sherry Williams. Denise Winfrey. Judy Ogala.
Yes.
Herbert Brooks. And Chairman Frankie Pretzel.
I'm a no. But motion carries
4-1 approve.
4-1. Congratulations. Next on the agenda, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case ZC 24090, Chicago Title Land Company, owner of record, and Tiffany Grace with New Lenox Community Energy Initiative, LLC, agent, Kyle Berry of McGuire Woods, LLP, attorney, requesting a special use permit for a commercial solar. Did I miss one?
You missed 5.
I apologize. I'm going back one. Number 5 on the agenda, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case ZC 24094, Mohammed El Sharif and Thira Aish. I apologize if I'm butchering names. Owner of record requesting a special use permit for a similar or compatible use to a permitted use for a group care home in Frankfort Township, commonly known as 7551 West Hickory Creek Drive, Frankfort, Illinois, 60423, County Board District Number 3. And I'm looking for a motion and a second. We have a
Second Ogala.
motion, second Ogala. Okay, Ashlyn, want to let us know a little bit more about this one?
Yeah, so the subject property is in Frankfort Township. Village of Frankfort is about 0.2 miles to the southwest. Village of Tinley Park is about 1.3 miles northwest. Village of Matson and the Village of Richmond Park are also within the 1.5 mile radius. Group care home is currently permitted as of right in the R5 zoning district. Although his age is not considered a disability, the applicant is requesting approval of a special use permit for a similar or compatible use to a group care home, maximum 6 residents. The applicant owns Reef Residences Assisted Living Facility, allowing up to 6 residents who are physician certified and otherwise qualified under the Illinois Assisted Living and Shared Housing Act to live on the property until more advanced care is required. This type of housing is ideal for seniors over the age of 55 who require assistance with 1 or 2 daily activities, including bathing, dressing, managing the schedule of their medications, eating, housekeeping, etc. There will be a caregiver on site 24/7 to assist the residents living there. All systems in place will follow Illinois Department of Public Health protocols. As indicated by the applicant, residents will not have vehicles on the property. The only people with vehicles will be the caregivers and any additional support personnel that would be needed at the site, including medical professionals and family visiting. The family will not provide any nursing care, the facility, sorry. The facility will not provide any nursing care such as wound management, administering medicines, or assisting patients. Additionally, there will be visiting hours daily for friends and family and quiet hours for the residents at night. Of the agencies notified, no one objected. The Village of Tinley Park sent comments stating that they have no objections for the use and the location. The Village of Frankfurt also sent comments stating no additional review is required, and within the village, the use would also require approval of a special use permit. And then in the staff report, the Frankfurt's comments is included. After the staff report was published, staff sent out 3 memos. 3 were sent out with comments received from concerned citizen, and 1 memo was sent out including comments received from a nearby senior group care home, which was approved on March 21st, 2024 in front of this board. At the PZC meeting on December 17th, there were 7 objectors with concerns due to opening a business in a residential area, no benefit to the neighborhood, the house being too small for the use, issues with it being transferable, no street lighting, safety, care policy concerns, parking, noise, and not right for the community. At the Planning and Zoning Commission, they voted to amend condition number 2 to read, special use shall only be permitted for Muhammad El Sharif and Thera Aish. The Planning and Zoning Commission voted to approve the special use permit with the 5 amended conditions with the vote of 3 to 4, thereby denying the request. And staff is recommending approval of the special use with the 5 conditions, and I'm happy to answer any questions.
Okay, thank you. Do we have any questions from this committee before I invite up the applicant? Okay, I see the applicant is here, I think. You guys, I invite you up to the microphone. Welcome. Please introduce yourselves to.
Good afternoon. My name is Mohammed Al Sharif, and I am co-owner along with my wife there, Aish. We did have slides to present. So starting off, we're presenting Reef Residential Assisted Living, a senior group care home at Hickory Creek Drive. So a little bit about us. So my wife, Thera, completed her degree as a nurse practitioner, and she has years of experience under her belt working in several different units as a nurse manager on site. So those units covered included med surg, included being in the ICU, and included other acute care and long-term care facilities as well. And what we're looking to do here is to utilize her experience as our care director on site. And then I myself would oversee the operations, having over 8 years of experience in healthcare fields, ranging from nursing homes, skilled nursing facilities, and venturing into assisted living space as well. And that is all about us. So about our plan. So Reef Residential Assisted Living will target all seniors over the age of 55 who need assistance with one or more daily activities such as bathing, dressing, or managing the schedule of their medications. We will not have personal staffing directed towards direct nursing care, rehabilitation, or administering medications. And no matter the resident, we will deliver a caring, comfortable environment with a resident first focus in every aspect. We will house a comprehensive array of services that will appeal to our target clientele of seniors. And this will include assistance with everyday living needs through trained caregivers, a dining program, emergency call systems and 24-hour security, exercise education and individualized activities, health and wellness programs, housekeeping and laundry services, social and religious programs, and transportation accommodations. So I'm gonna stem into a little more about why we chose this property specifically for this project. And as you'll see in these next couple of images, this property was recently renovated in 2023 prior to a purchase of it. And we really put in our life savings towards this project as we went and saw several homes, but this home just had such a nice, vibrant look to it. It was an open concept. So we really like that idea of having kind of like a communal space all around in our property. And as you could see through that window, and I'll show you a closer look, it overlooks out into a pond area with a lot of greenery. So helping with positive energy in our facility. So this is a view of their kitchen, and then it opens off into a view of like a family room, living room space, along with a dining room. And then in this next image, it's just another perspective of that family room looking out into those windows with all that greenery in the pond right in the yard over there. And then this is a separate living room space. So that entire open space leads into this. So this will be a space dedicated to like a quieter time, maybe meetings with families, or maybe like having like a reading corner set up. And this looks into the patio area. So this is bedroom number one. Bedroom number one is 10 by 10 square feet. And then this is the primary, it's 19 by 15. And this is our third bedroom, which would be 10 by 13. And then here's that view that overlooks from the inside of the home. And then the patio area. So current zoning in the R5 district. So the zoning ordinance definition, as Ashlyn mentioned, is already approved to have a group care home on site. So a group care home by definition is a dwelling shared by persons with disabilities who live together as a single housekeeping unit in a long-term family-like environment in which staff persons provide care, education, participation, and community activities for the residents with a primary goal of enabling the resident to live as independently as possible. So our request for special use of the already permitted zoning ordinance would be following this definition, the use is permitted in the current zoning district. However, since age is simply not classified as a disability, we are requesting for approval of a special use permit. We are requesting approval of a special use permit with a similar or compatible use to a permitted use in the current zoning district. And this would not be a rezoning, but again, just asking for that special use. So then I wanted to cover a little bit about the Fair Housing Act. So the Fair Housing Act, which prohibits discrimination based on race, color, religion, sex, familial status, national origin, or disability. This act has been interpreted to protect individuals with disabilities, including seniors who may require assisted living services, also supporting including them within residential areas. So under FHA, seniors who require daily living assistance qualify as those defined as having a disability, and not permitting seniors who deem capable of receiving rights within a residential community can contradict the rights under FHA. And our goal is to advocate for our senior residents and ensure that they receive a safe and tranquil living in our space. So types of residents we will serve. So we'll serve residents that are looking for basic non-nursing care needs, where those needs are not advanced enough for skilled nursing facilities, nor does the resident want to be placed in a larger non-residential facility. So we aim to be that bridge transition to transition your loved ones from independent care to their next journey. Our residents will strive to have a home style setting where they are receiving this assistance for their 1 to 2 daily living activities, such as like toileting, bathing, feeding, etc. So I just want to throw in a little example. None of the names here are actual names of residents, as we don't have residents yet. So for example, John is an 85-year-old man with arthritis, mainly affecting his knees. He transfers by cane, but can use a little help getting around and being provided daily care. Our caregiver, Jenny, will assist John in getting out of bed, his bathing routine, and John will receive our home-cooked meals at our facility. John's son and his daughter-in-law are unable to assist John as they were able to in the past, since they have 3 young children, and both are working full-time. John's children really did not want John to be placed in a large facility, given that he was at that level of care, but they knew he needed a community to engage with and to feel at home. So that's the kind of resident that we're looking for to bring into our facility. And then a little more on the types of clearances that we're going to have prior to be admitted to our facility. So we're going to have a mental health / physical / background clearance. So all residents admitted to our facility will require a physician's clearance to deem fit for our program. We will not be able to accommodate for any persons with advanced illnesses requiring direct nursing care, such as wound care, et cetera, dementia, or psychiatric diagnoses. We will also conduct background checks to ensure that we are not admitting any national or state identified offenders, and fully conduct background checks to ensure the safety of our community and our facility. So parking and visiting. So no residents living on site will have cars at our facility. Visitors can come during operating business hours and by any appointment basis for safety and traffic purposes. And our staff will be parked inside our garage, and we will have 2 spots on site for visitors coming in, as it's a 2-car garage. Our ADA compliance. The only updates made to the inside of the house will be based on being ADA compliant, which is the Americans with Disabilities Act, and this will include railings in bathrooms, ramps to entrance and exit, and amongst other minor changes as well. And then Illinois Department of Public Health licensure. This licensure can only be obtained after the zoning process is successfully completed. However, we want to assure the board that we will not operate the home until the IDPH license is secured and all state requirements are met. And the IDPH will be openly permitted to visit our premises, as well as visit on site for our annual inspection to make sure that we're in compliance of all care needs. And that concludes our presentation.
Thank you. A couple questions. Beautiful outside patio area overlooking the pond there. I like that. I assume there will be opportunities for the residents to spend time outside. How do you ensure there's no wandering and, as people get older and things aren't working the same? How do we make sure they're not walking down the street?
Yeah, absolutely. So we're definitely going to have that clearance prior to being admitted for those reasons, to make sure that we're not at any signs of any levels of dementia yet, and making sure that even if we're advancing towards that my wife, as our care director, is constantly making sure that they're still appropriate for our facility. And if it takes requesting that the family takes them for another physical clearance again to make sure we don't head towards that, then that's what we would have to request from families. And then in terms of taking those walks outside, I mean, that would definitely be something that, say my wife and I are on site and the caregiver's on site, that one of us would have to accompany them in that instance then.
Got it. Thank you. Any questions from the committee on this? We do have a question. Member Williams?
Just wanted to know, is it 4 residents or 6 residents that we're talking about?
6 residents.
Okay.
2 per bedroom?
Yeah, 2 per bedroom. Anticipated, yeah, 2 per bedroom.
Okay. Any other questions from the committee here? All right. Thank you. Do we have anybody else here to speak on this case?
Hi, my name is Joe Brady. I live in the home directly east from the house that they're talking about. And I've been living there for 26 years. I raised 2 families. I'm a blue-collared railroader, retired, and so I'm working a part-time job to kind of keep ends meet. And unfortunately, a lot of my neighbors couldn't be here today because of work and kind of lack of knowledge of this meeting, since the day changed, but hopefully for the next one we'll be here. So I'm not a good speaker, so I'm just going to read some. Bear with me. Unfortunately, a family had this home on contingency in which there was a bidding war and the business owner won out. The district has closed some schools in the Summit Hill District a few years ago and Lincoln Way North High School. If this is allowed to continue, business will be buying up our affordable single homes, family homes, and we might find more schools closing in the future. Another cause for concern is there's quite a few families on Hickory Creek Drives with little children, And I fear that the parking situation may also be a hazard to children. With fire hydrants, mailboxes, and driveways, parking will be limited. I know children like to cross the streets to get to their homes, bus stops, schools, and parking lots. I'm afraid that the children may be crossing the street between parked cars. The road curves just before this home, which could also pose a hazardous situation. Also, the street lighting, there is very little street lighting, so at night it's dark. None of the homes are fenced in, so like as you mentioned, people wandering at night, I worry about, opening my back door, there could be somebody right there. I walk my dog at night. Also, one of my concerns is my property value. This is all I have. And I know a lot of my neighbors around there were all scared that if this comes in, is our property value going to drop? 5, 10, whatever the percent may be. I mean, I can't do it. Can't live with it. But, and then just a reminder to tell you that the zoning commission did deny them and they did deny the transfer. So I'm hoping that you will deny the permit. Thank you.
Thank you for being here. Anybody else here to speak on this one? Okay, I'll just say my only concerns on these, and we've had another one, is just the idea of having these businesses in these residential areas in subdivisions, homes are close together. Those are my concerns, but go ahead and call the roll, Dawn.
Special use permit for similar or compatible use to a permitted use group care home, maximum 6 residents with 5 conditions. Sherry Williams? No. Denise Winfrey? Judy Ogala?
Yes.
Herbert Brooks?
Yes.
And Chairman Frankie Pretzel?
No.
3-2.
3-2, motion carries. Congratulations. Okay, next on the agenda, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case ZC 24090, Chicago Title Land Company, owner of record. Sorry, there's so many. Tiffany Grace with New Lenox Community Energy Initiative LLC, agent Kyle Berry of McGuire Woods LLP, attorney. They're requesting a special use permit for a commercial solar energy facility, a variance for the number of required mowings from 5 times to 1 time per year, a variance for the maximum ground cover plant height from 13 inches to 36 inches. This is in Monee Township, commonly known as 6952 West Bruns Road, County Board District Number 3. Can I please get a motion and a second?
Motion O'Gala.
Motion, second. And then Ashlyn, do you want to give us a little bit more information on this one before I hand it over to the applicant?
Yeah, so just like a thing to point out, the applicant is requesting the agent listed on the application to be amended to Tiffany Grace of Monee Community Energy Initiative LLC. So it is being amended for moving forward from here.
Okay.
The subject property is within Monee Township. Green Garden Township is adjacent west. Village of Monee is directly to the east and south of the property. The Village of University Park and the Village of Frankfort are both located within the 1.5-mile radius. Applicant intends to use 52 acres of the 168-acre parcel for the community solar energy facility. Applicant is proposing to construct a 4.95 megawatt commercial solar energy facility with 13,275 solar panels. Per the project narrative, the project is proposed to power about 990 homes. Based on the terms of the lease agreement, the solar facility could exist on the property for about 25 years with the ability to extend the lease 3 additional times, each for an additional 5 years. Dependent upon zoning approval, the applicant has entered into a purchase and sale agreement to purchase the 52 acres. Of the agencies notified, no one objected. Monee Township provided comments after the staff report was published, objecting to the 2 variances being requested for plant height and the number of mowings. This was sent out as a memo. The township specified that they were not objecting to the special use permit, specifically were objecting to the 2 variance requests. After the staff report was published, staff also sent out 2 memos, including letters of support and a memo including comments received from a concerned citizen. At the PZC meeting, 10 objectors were present, bringing up concerns with more taxes, pipeline in the area, flooding, too close to adjacent homes. more covering needed, market values in the area, concerns of area moving towards commercial, roads not being able to support the fire trucks, traffic concerns, looks unappealing, too much heat generated, etc. At the PZC meeting, the board voted to approve both variance requests with a vote of 7-0, thereby approving both variance requests. And as a reminder, the variances are not heard at this meeting. The PZC board recommended approval of the special use with the 4 conditions with a vote of 5-2, thereby approving the request, and staff is recommending approval of the special use with 4 conditions, and I'm happy to answer any questions.
Thanks, Ashlyn. Do we have any questions for Ashlyn or staff? Okay. It's to answer that, want to say that in the microphone, sorry.
I believe the request for height and the amount of moist is what we have been mostly approving of late anyway, isn't it?
Yeah, with previous solars, it's a pretty typical variance request that we've seen.
Thank you, Ashlyn. Okay, welcome. Please introduce yourself and your team.
Sure. Good afternoon. My name's Colin Walker. I'm the development manager for ECA Solar. I have the team behind me. We'll start with Ben. He's director of civil. We have Carrie. She is from Atwell. We have Andrew Lines. He's from Cone Resnick. And Tammy, you will be supporting. Sorry. Perfect. So, that's okay. I have a presentation. I just like to start with that. Perfect. Thank you. So as mentioned, my name is Colin Walker. I'm here to introduce Moni Community Energy Initiative to everyone here. If you go to the next slide, please. I'm from ECA Solar. ECA Solar is about to turn 11 years old in February. We are a 100% employee-owned company. We have in-house skill sets, including finance, development, engineering, etc. And we specialize in community scale development. We've developed community scale solar throughout the United States. And most importantly, we have 30 plus projects here we're developing throughout Illinois. Moni Community Energy Initiative is what you're seeing up on the screen now. It's ground mounted solar. It roughly powers 990 homes. It's 4.95 megawatts AC, sited on that 160 acre parcel. What's important to note here is that we are purchasing 52 of those acres, and we are actually only going to be putting the solar on plus or minus 37 acres of the 52 that we are purchasing. The remaining acres that we are not purchasing will remain farmland, will continue to be farmed. And then there's just a couple things that are not up on this project overview that I'd like to highlight. So in the summer, we actually held 2 community outreach meetings with the neighbors. We sent out about 72 letters to neighbors, and we had those 2 meetings. We listened to their concerns, we answered their questions, and some of the changes that we made to our site plan reflect those comments that we heard, including putting the access drive as far south as we possibly could. We're wrapping the entire fence with a green mesh that allows some visual relief while the vegetation that we're going to be planting grows. We are adding a 3rd row. So normally there's 2 rows, but we're adding a 3rd row of plantings off of Harlem Ave. So north to south on Harlem Ave to, again, put that visual buffer. We are also going to be limiting the tilt of our single axis tracker as it rotates through the sun. It was causing some glare. We're now restricting that tilt so that there is no more glare. And last but not least, we're actually going to be putting in a sound acoustic dampening wall around the noise making portions of this site, because one of the things we did here was concerns with noise. And so we're going above and beyond. We are already meeting the Pollution Control Board's recommendation, but we're now putting this in place to further alleviate any concerns. And with that, I will turn it over to Ben.
Ben Dykema, the Director of Civil Engineering at ECA Solar. So this slide here just shows the visual screening. As you can see, we are going to be putting a visual buffer or a screening buffer, vegetative buffer around the entire site. This is going to be in line with the ordinance, which, includes evergreens, deciduous trees, as well as shrubs. As Colin mentioned, along Harlem Avenue, we are going to actually go a little bit beyond the ordinance. We're going to plant a third row of evergreens there, just because that was a community concern. This just shows some project renderings. These were shared earlier too with some members of the community, just so you can kind of see what this would look like with the visual screening buffers there. Next slide, please. Great. And this slide here just showing, so, we talked about the variances that were requested. What we're proposing for vegetated cover at this site is going to be a pollinator mix along with native grasses. The reason for the variance requests are just because over mowing of these types of vegetative covers actually prevents the propagation of the vegetation. We don't want it to die. We want it to obviously grow and cover the ground. A lot of benefits to this type of vegetated cover, including ecological benefits. Deep root systems help water infiltrate into the ground. It also helps with soil, bringing nutrients into the soil. And with that, I'll turn it over to Carrie with Atwell.
Hi, Carrie Williams, Atwell. I'm a civil engineer working on the project. I prepared the plans and helped with the permitting entitlements of the project. And this, the project is proposing, we will be under 25,000 square feet of impervious. We're at 24,920 square feet. Therefore, we are under the threshold for stormwater detention. So the project will not be required to do any stormwater management on site. We are implementing gravel road and also a green turf travelway. That was also reviewed with the Fire Protection District. And with that reduction in stormwater runoff from existing to proposed conditions, we're not adversely impacting any of the drainage patterns or impacting any off-site properties. We are maintaining the existing stormwater management on site. Next slide, please. We also had our consultant prepare a drain tile study. It is determined that there are some drain tiles on site and they are subsurface. They're shown in red on the exhibit. At our last public hearing, our consultant was here and represented the findings of the study here. And based on the project, we will not be adversely impacting anything. We're proposing to, if any drain tiles are in the limits of our disturbance, we will be replacing those with PVC material and instilling the integrity of the pipes long-term and not causing any adverse impacts to any properties off-site, and also maintaining existing drainage patterns subsurface on the project property. Thank you.
Thank you.
Hi, everybody. Good to see you all again. Andrew Lyons, real estate appraiser, property value impact. You guys have heard from me before. Again, this is a pretty nice little site. It's a really small project. It actually probably provides a little bit of buffer from the Amazon facility that's kind of adjacent and kitty corner to this. So whatever future development either happens to the south or to the west, this will serve as a bit of a buffer. Again, I don't know if you know this, but an associate professor at Loyola University of Chicago did a study this past year on 70 different utility scale projects and indicated an increase of nearby property values of 0.5 to 2%. I've been studying this for almost 10 years now. The reports which have submitted have a number of data points and about 10 that I had studied, but that's only a snippet of everything I've covered coast to coast. I've analyzed hundreds of data points on this issue, that including my analysis of other academic studies. I don't believe that there's any fear of putting in a solar farm like this into a small community where this is located. I'm happy to go through a longer and larger deck if you guys have interest. But in light of the fact that you guys have already approved a number of these developments over time, I probably think it's not necessary, but happy to do so upon your request. Thank you.
Thank you. Okay. Did you want to talk? I don't want to leave anybody out.
Only to wrap up and say that we're happy to answer any questions you might have.
I'm looking at pictures now. What is the property being used for today?
It's currently farmed.
Yeah, corn. Okay. See. Okay, thanks. We have any questions?
52 acres in Will County, all 52?
Are in Will County? Yes. Yes.
Okay, thank you. Is there anybody here? Member Freeman?
Thank you. I am just curious about your vegetation and your trees. Are they all native?
Yes, what we're proposing for the vegetative cover would be all native. We would go to a local nursery for the vegetative buffer as well as for the seed mixes. Yeah, native grasses and pollinators.
The trees will be native as well?
Yes.
Thank you.
For them? Yeah. All right. Member Ogala?
Yeah, so I have a question. We did put together that solar guidelines. My iPad died and I'm sorry for the holiday. I didn't get to read everything. Were they given the solar guidelines packet with the questions that we had come up with?
I did share it with them, but they submitted after it was approved or before it was approved.
Okay.
So it wasn't out yet.
It wasn't out yet, so I would say you guys should brush up on that because when we come to the full board, you will be asked a lot of those questions. I will have some of those for you guys now. You said a green mesh, so you're going to be putting in a chain link fence and you're going to put green mesh in? What are you meaning?
Yeah, it's an agricultural fixed knot wire fence, and then there'll be like, if you go past construction sites, you see a green mesh kind of woven in. It'll be exactly like that, basically, so you can't see directly through.
So it's a chain link fence or, no, it's an agricultural
Ag
fence?
fence, yes.
An ag fence with the mesh in it?
Correct.
Yeah,
Yep.
I think the people will not like it once they see it. I live in the country. I drive past this area every day on the way to work. So I know that for me, a wall in the middle of the country looks ridiculous. That's my opinion. So I have several questions. One, as far as you guys are going to purchase this 52 acres. Okay, so what I've seen issues that have come up is when the solar company has purchased the land, okay, and they haven't done any kind of prep on it prior to the installation of everything. We've had a lot of issues with getting the plantings in place, maintaining those, and keeping those and getting them to the point where it's good for any kind of runoff or anything like that. That's been a definite problem. So I think that one thing I think we as a board need to look at is saying, when do these things get built? Like, is it during the growing season? Is it not during the growing season? Because that impacts the growth of these plantings. So my husband and I have a conservation award-winning farm. We've put in all these native species and for habitat of all different types on our property. So I know the time that it takes to develop it. And I know that eventually you do need to cut because trees will grow within this on occasion, of course, too. So you have to keep those mowed. So that's a concern of mine. Another concern is everyone wants plantings around this in the country. What I see all the time is you have a tree here, a tree there, a tree there, and in between is nothing but weeds. It's not like grass is planted between the shrubs and the weeds. It's just, put a hole in the ground, you dump in your plant, a bush, a tree, whatever, arborvitae. And then in between, because there's open land in between, nothing happens. So what is your plan for the areas in between? Because the way I see it, for these solar facilities, they have the trees and bushes, but in between it's just weeds. And so the bushes end up being overshadowed because now the weeds have grown up in between. Because unless you're going to take a mower out there, I don't know how you mow around this. So what's your plan for that?
Yeah, I was writing down the concerns, so I'm just going to go through them here. So I think your first concern, actually, we were talking about the mesh. So the mesh that we're proposing is not intended to be permanent. We're looking at about probably 3 years. And really, it's there just because, when we first plant the vegetative buffer, those plantings are going to be about 6 feet or so. They're not going to be fully developed. Obviously, transporting a fully grown tree doesn't typically work well. So the intent for the mesh fence is just to kind of act there temporarily until we get more maturity with that visual screen, and then it would, it would be removed. So it's not intended to be there. Excuse me. Also have a hoarse voice, long term. As far as the maintenance of the vegetative cover, so I understand that concern. We do have an O&M plan that we did put together for this. The intent is to continually monitor the vegetative cover. We're going to be following the Illinois Department of Agriculture's guidelines for the pollinator seed mix and all their recommendations. They do recommend mowing, earlier on when you prevent it as a means for preventing weeds, trees growing up in between. Typically that does die down, certainly in years 2 and 3. As the native grasses and pollinators kind of, fill out and then crowd out basically any opportunity for weeds to grow. Ongoing throughout the lifespan of the project, the operations, we will be monitoring if there is any areas that where vegetation is sparse. The O&M plan does call for reseeding in those areas. Same thing too, if there is an area where trees or weeds are coming through, even if it's years 4 or 5 down the road, we can do spot mowing. So those are types of operations that we are planning on putting in place for the longevity of the project. And then the last about the area on the buffer, we are engaging we will be engaging with a mowing company. I think it's very feasible for us to make sure that they do mow on the outside of the fence too, around the trees and making sure that we do maintain that area as well.
Well, that would be the first that I would ever seen on any solar facility in Will County, because I've not seen one that the plants are there, the plantings are there on the outside, and it just is, and it's a disaster. So I was just curious then, what has your involvement been with the Soil and Water Conservation District, if any?
So we did submit for our NRI review, and we received our report back, and then they came back to us and said prior to construction, they want to have a pre-construction meeting with us on site, and gave us conditions as part of that, submittal items that need to be required for review. We'll prepare a conservation plan for their review and approval prior to going to construction.
That's good, okay, because that's very important. I find that in the past, because we're learning, as a board, we're learning how to deal with these many solar facilities that are popping up all over Will County, as to how we can handle it within the guidelines that the state has put on us. And one of the biggest issues is to make sure that there is a good conversation and a good relationship between the developer as well as the Soil and Water Conservation District, because they make sure that we have things in place that need to be. Now, I know that area, like I said, I drive past that farm on my way to work. So I know that there isn't a huge issue with the topography of the land. It's not, a real difficult property or anything like that. So that makes it easier to make sure that these things grow well and stuff like that. I am happy you have an ag fence. That's a good thing. I think that's all I have for right now.
Thank you. Member Ogalla, any other questions from the committee? Okay, is there anybody here from the public that would like to speak on this case? Okay, if there's no other questions, I think we're ready to vote.
Special use permit for commercial solar energy facility applies to 52 acres with 4 conditions. Sherry Williams? Denise Winfrey? Judy Ogalla?
No.
Herbert Brooks? And Frankie Pretzel.
Yes.
4-1 passes.
Okay, thank you. Congratulations. Ordinance amending, next on the agenda, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case ZC 24101, Smith Land Holdings LLC, owner of record. Brent Buschberger of Summit Ridge Energy LLC, agent, requesting a special use permit for a commercial solar energy facility in Manhattan Township, commonly known as vacant West Smith Road, Manhattan, Illinois, 60442, County Board District Number 2. Can I get a motion and a second, please?
Motion O'Gala.
We have a motion, we have a second, and then Kelly, please tell us what we don't know about this one.
Okay, the applicant is Summit Ridge Energy. The applicant is proposing to construct a 4-megawatt commercial solar energy facility on a 50-acre parcel. The parcel is located in Manhattan Township along West Smith Road. The applicant is requesting the special use permit to apply to all 50 acres, but only approximately 26.82 acres are proposed for the solar energy facility. Staff did receive a letter of objection from the Village of Manhattan. The reason for the objection was the future land use of this parcel is residential, and the proposed solar energy facility would disrupt the residential development. Staff also received comments from Manhattan Township. The letter states that the township and road district are not in objection with the solar facility if it meets all regulations and requests of Manhattan Township. The applicant has been working with Manhattan Township and the road district. Also, the applicant has updated their site plan since meeting with Manhattan Township. The Planning and Zoning Commission voted 6-1 approving the special use permit, and staff is recommending approval of the special use permit for the commercial solar energy facility with 4 conditions. And the applicant also has a presentation prepared for you guys, and I'm also happy to answer any questions.
Okay, thank you. We have any questions from the committee for staff? Okay, I invite the applicant to the microphone. Good afternoon.
Hello, everyone, and Happy New Year. Thank you, everyone, for having us here today, especially the staff, public, and members. I'm Bridget Callahan. I'm here with Summit Ridge Energy. I'm here to present a community solar project to you, and I am here in place of Brent Buchberger, whose name appears on some of the other materials. Staff already mentioned, but this project was presented to the Planning and Zoning Commission December 17th. It did receive a recommendation for approval with 4 conditions. We do have a couple of slides prepared that I'm happy to run through. If we could please move to the next slide. Okay, wonderful. So this project is proposed on approximately 27 acres of a 50-acre parcel. It's located along Smith Road. The site entrance is proposed approximately 1/4 of a mile east of the intersection of Cedar Road and Smith Road. So that's outside the Village of Manhattan. Next slide, please. The project parcel is zoned as A1 agricultural, and all of the abutting parcels have the same zoning of A1 agricultural as well. And the next slide, please. As the staff mentioned, we did want to highlight some of our ongoing engagement that have been impacting the project plan. So we have been working hard to consider some of the comments from Manhattan Township, the fire district, and the staff report recommendations as well. So with that feedback, we have made several changes to the site plan. Some of those are highlighted on this slide, and then on the next slide, I'll show the site plan itself as well. So we do have an increased front yard setback from Smith Road that came from a township request. We did also increase screening for the project based on feedback from the township. So we are showing screening on the north section along Smith Road, as well as portions of the east and west sections as well. We'll be able to see those a little more clearly on the next slide here in a moment. Regarding the number of poles on site, regarding Manhattan Township's preferences, as well as the staff recommendation, we did update the site plan to switch from pole-mounted equipment to pad-mounted equipment. The point of interconnection, what that means is fewer poles overall for the project. The staff also did recommend that we comply with fence suggestions from the Illinois Department of Natural Resources. The township did provide feedback that a traditional wire mesh or cyclone fence is preferred rather than the agricultural style fence that was mentioned with the last applicant as well. So our current proposed plan is to use the wire mesh fence and then include a 6-inch clearance at the bottom. That's based on the Department of Natural Resources recommendation that comes through the EcoCat report, but we are open to further conversation regarding the fence. We are also continuing to iterate on the access road as well. We want to make sure that the emergency responders do not need to travel more than 600 feet from the access road. That's regarding comments received by the fire district. In addition, this was briefly mentioned by staff as well, but we do understand there's some concerns with regard to the width of Smith Road. So we are required to enter into a road use agreement with Manhattan Township, and we are investigating the scope and costs for improvements to Smith Road with regard to this development as well. We so far have a preliminary scoping visit, and we have kicked off a consultant as well, just to provide more information as to cost and scope there. If we can move to the next slide, please. All right, so understanding this may be a bit hard to see largely, this is the intended site plan at the moment. So if you can see on the north or the top of the slide, there is sort of a green section that indicates the screening for the project that's currently intended to be arborvitae, as similar on other solar project developments in the state. Two comments just that I did want to end with as well. There is some residential development in the area, surrounding areas. One thing I did just want to mention about this project site that I think the public may be interested in, there is a transmission line running on the east section of the parcel, and there is the water features to the west as well. So, we believe based on that this parcel would not be, suitable for residential development, or maybe not the most desirable based on those two features that almost present a natural buffer on the east and the west. With that, I will wrap up, and I'm happy to answer any questions.
Thank you. I do have a couple questions.
Of
So
course.
I'm pleased to hear that you're working with the Manhattan Township and Village of Manhattan on some of their requests. When I hear we're looking into or we're exploring improvements to Smith Road, I just wonder what exactly that means. Because you could look into it and then you find out it's really expensive and say we decided not to do that. So what does that mean exactly?
Yeah, so where that process is currently, we have received a scope and cost back for the engineering section. So just design and engineering, what it would look like, the cost and scope for the engineering to sort of either design the road or widen. The consultant is in parallel also working on the cost and scope to actually improve the road, if that makes sense. So currently we only have the cost and scope for the engineering and design. We don't have the full cost and scope for the work itself. And that is expected back middle of this month in January. So that's where we are in the process. Of course, there's always a cost at which something is unfeasible. So we do need to receive that proposal back, which is in progress.
Okay, and then I'm looking at the other notes from the Manhattan Township here. A decommissioning bond, you guys committed to doing that?
Yes, so with this project and any project on agricultural property, we're required to enter into the Agricultural Impact Mitigation Agreement, or the AIMA. And as part of that, there is a requirement for a financial assurance that we typically use a surety bond And that would typically be held at the county level unless there's a specific preference otherwise.
That's all I have.
Thank you.
You guys have? Okay, Member Ogala.
Thank you. So I have a question on the fencing, and what I think would be great is if we start get a picture of what fence they're going to use, so we can see what that fence looks like, rather than just imagine what it might look like. So that the board members can all see the fencing that we can expect to look at.
In this one, they did,
Is it in
it was requested that they put a chain link with a top rail.
a chain link with the top rail?
That's what Manhattan's asking them to put in, and they agreed to it, I understand.
Correct. Yes, and that's what's currently shown in the latest civil set as well.
What does the top rail have on it?
To keep it from sagging, that's what it says in the notes was.
Yeah, that's correct. Is your question asking about barbed wire perhaps, or
Oh, I'm
just?
hoping there's no barbed wire.
Yeah, there wasn't any in the civil set upon review. It just said proposed chain link fence with top rail as stated.
Okay.
Correct.
Okay, and what are your plans with vegetation on the outside? You sat here and heard the last questions I had, and that what I've seen, a lot of solar have been built in where I live. I live in Eastern Will County, and it's kind of moving out west now, but so I see the stuff that exists there. I've seen companies that had plantings all the way around, and whoever did the plantings didn't finish planting. The holes were dug and the bush was there in a pot on the side, and the pots were just dumped on the side. And unfortunately, it takes the residents to verify that it got planted and those pots get picked up. I mean, it's really bad. I'm going to make it an effort now that I'm on the land use committee after many years of being off to get out to these places and make sure that's happening, because it's sad when industry such as solar comes to an agricultural area and then they just don't take care of it. That's upsetting to me. So what is your plan on the outside, if you have any screening preventing the weeds from growing up in between the arborvitaes?
Yes, absolutely. So similar, I'll just kind of say the similarities and differences from the last applicant. So the only difference on the land use side, this is a lease rather than a purchase to buy or an option to buy, excuse me. So we as the applicant would be responsible for operations and maintenance for the entire leased area. That would include anything inside and outside of the fence that we're leasing from the landowner. So as to your questions, the arborvitae are on the north and the east and west. So noting this specific concern about vegetation management between the trees as well. So we do typically mow the site several times a year. This is a pollinator-friendly habitat, as heard from the other applicant as well. So, on the majority of the fence, it shouldn't be too difficult to mow, right up to the fence. Our O&M providers are the people who do the vegetation management periodically, would be weed whacking as well in between the trees, so on the north and east and west side.
That's good. Good to hear. I like that. And what has your involvement been with the Soil and Water Conservation District?
I apologize, but I do not have an answer to that question, but I'm happy to follow up on that item.
Okay, because it's very important. Like I said, we found that in the past, we didn't have soil and water involved as early on. And now they have the pre-construction meetings where you go to the site, you walk the site with soil and water, and then they can look at it. And you do have water that's running through yours, so they would probably have some suggestions there for possibly additional plantings or different plantings along that area. So hopefully you'll have that information for our full county board meeting. That would be great to have that, because it's really important to make sure that we're not, doing anything negative to the water areas. So that would be good.
Okay, thank you.
Thank you.
We'll have that ready for you as well.
Anything else?
No, that's it. Thank you.
Any other questions from the committee? Okay, thank you for being here. Do we have anybody else that would like to make a comment on this case? Last chance. Okay. Dawn, go ahead.
A special use permit for commercial solar energy facility with 4 conditions. Sherry Williams, Denise Winfrey, Judy Ogala,
No.
Herbert Brooks, and Chairman Frankie Pretzel.
No. Motion carries 3-2.
3-2.
Thank you. Okay, last under new business, ordinance amending the Will County, Illinois zoning ordinance as amended for zoning case ZC 24110. Foss Farm 1 LLC, owner of record. Angela Feria of Anemone Solar LLC, agent. Kyle Berry of McGuire Woods LLP, attorney, requesting a special use permit for a commercial solar energy facility, a variance for number of required mowings from 5 times to 2 times, variance for maximum ground cover plant height from 13 inches to 24 inches. This one's in Joliet Township, commonly known as vacant New Lenox Road, Joliet, Illinois County Board District Number 6. I need a motion and a second, please.
Motion. Okay.
We have a motion, second Ogala. Okay, Jesus?
Yes. So zoning case 24110 is in Joliet Township, about 1,300 feet east of the intersection of Brick Street and New Lenox Road. The applicant is proposing to construct a 5 megawatt community solar project. The special use areas for the entire 18.7 acre property, but the solar development will only encompass 13.2 acres of the property. The project could exist on the property for about 40 years if all options are exercised. The applicant is proposing about 12,664 panels on the site. Per the submitted site plan, the panels will meet the required 50 feet setback from adjacent properties, 100 feet from the nearest point of outside wall of a dwelling unit or occupied community building. The equipment pads for the project will be centrally located about 411 feet from the nearest point of an outside dwelling unit. Community Horn performed a noise assessment and concluded that the noise generated by the inverters when they are located greater than 250 feet will be about 45 through 50 decibels. No full-time staff will be on site. The property will be remotely monitored 24 hours a day. There were concerns citizens at the PZC meeting. Their concerns included proximity of the project to their homes, property values, draining, flooding, and sound concerns. Staff recommended approval of special use permit with 4 conditions and the 2 variances for number of required mowings and plant height. At the Planning and Zoning Commission itself voted to approve the special use permit with a vote of 4-3 and voted 7-0 to approve the 2 variances. With that said, I'm happy to answer any questions.
Thank you. Questions from the committee? Okay, I see the applicants here. Please step up to the microphone. Introduce yourself.
Good afternoon. My name is Tom Londrigan. I'm here on behalf of Kyle Berry with McGuire Woods and representing Anatomy Solar, which presented before the Zoning Commission last month and was approved and met all the Will County special use permit requirements. It's a 5 megawatt solar farm. And I think I would draw attention to the uniqueness of this is that it is on a smaller footprint, 19 acres, and in large part based on the type of panels that Angela will here describe, which are about 4 feet high. With that, I'd like to introduce Angela Feria with Anatomy.
Thank you, Tom. Again, my name is Angela from Cultivate Power, and allow me to discuss some of the highlights from the public hearing, as well as just be prepared to address any questions that this committee might have. So there are 3 things that I want to highlight for this project. The site plan is not post-updated, but I have a copy of the site plan here, so I can maybe talk about this a little bit further. But part of our outreach before we even submitted the special use permit application with the county is that I conducted an outreach to over 24 neighbors. This is beyond what was required by Will County. And in addition to this outreach through letters, I also met with all of the adjacent neighbors in person on several occasions and conducted phone calls as well. Based on some of the neighbors' concerns, we redesigned the project to incorporate the following. First, in particular, you'll see it's very small, but in the northeast side of the project, we increased the vegetative screening in order to provide visual mitigating impacts to the neighbor just within in the north of that property. And then in addition to this, we also removed the solar panels that initially were directly east of his property. So we removed that so that the panels are fully set back from his property over 236 feet. And then also we move the inverters so that they're further away from the closest noise-sensitive use. And if you look at the site plan, the inverters, which are the only source of sound for the solar system, is 574 feet away from the neighbor's residence. Beyond this site plan, which we incorporated feedback, I also would like to highlight, I believe we also received the updated solar guidelines, and I reviewed the public agencies that moving forward we would be required to engage with. And in fact, even although we submitted the application before these guidelines were adopted, we have reached out to all of those agencies. And I would also like to highlight that the East Joliet Fire Protection District did submit a letter of support, and the Joliet Township Road District did sign a road use agreement, which we intend to fully execute this week. Finally, in terms of beyond what you typically see in economic benefits from the solar site consisting of local jobs, tax benefit, significantly additional tax benefits. We also would like to highlight the local impact that our company is striving to include in Will County, including first, we supported the Will County Farm Bureau Foundation, provided a scholarship for students pursuing higher education. Second, we also are continuing discussions with the Nature Foundation of the Will County Forest Preserve. I've been engaging with Director Taraneff in order to not only provide support for the Nature Foundation, but also work with them in order to consult for the local native pollinator-friendly plants and grasses, which will be including not only under the array area, but also in the open area. Third, we also have committed to supporting the Mount Olive Baptist Church, their community efforts, particularly in the workforce development and upgrading their community facilities. And at the public hearing last December, they did come and state that they're in supportive of the project. And just for context, their church is located directly west of the project site. And then finally, we also have launched a fully funded science, technology, engineering, and math program. The pilot school in Will County was Lincoln Way East High School. We funded 2 classes that built solar suitcases that these were then deployed to Marawi to provide electricity for schools in need. And our intent is, since we do want to continue working in Will County, is we would like to add 3 more new schools to this program, which we're continuing in this year. With that, I would just like to say that I'm here for any questions from this committee. Thank you.
Questions?
I don't have a question at all. This solar farm is in my district, Brooks is in mine, and we have talked to the Reverend Martin from Mount Olive Baptist Church. We are pleased with this facility.
Thank you for the comment.
And I concur with my senior colleague in my district. I'll be quiet.
Member Ogala.
Thank you. I'm glad that you had the solar guidelines. That's very helpful. And you can see these are questions we would have time after time after time, that we want to have the information, prior to all this information. I'm also pleased that you, unlike the other companies, are having involvement with the communities and giving back to the communities in various different ways. That's fabulous. I like that. What involvement have you had with soil and water? Because it looks like, there could be some issues with the lay of the land there as far as drainage, and also what type of screening has been requested of you?
Yes. So we did engage with the Will South Cook Soil and Water Conservation District, and they provided a natural resource inventory report. Part of that executive summary, their recommendation is twofold. First is to conduct a drain tile investigation in order to repair, maintain any existing drain tiles that could be impacted by the construction. And so this is part of our development process, in addition to the fact that it is required under the Agricultural Impact Mitigation Agreement. And then second is that the recommendation is to submit a soil erosion and sediment control plan prior to the site development permit or the building permit process. So we intend to submit this plan in coordination or in consultation with the Will South Cook Soil and Water Conservation District. And then in terms of the vegetation in the area, we did submit a landscape plan, and we intend to, it's not very visible here, but in the landscape plan, it shows an open area seed mix. So this is the seed mix that is not underneath the panels. So prior to construction, we'll be including a cover crop of oats, wheats, or rye, depending on the season. And then under the array, we have proposed shade, not only shade tolerant varieties, but also shade loving varieties, including fox sedge, fescue, and several other varieties, which we would intend to procure with the local nursery. And then if you see there is vegetative screening along the west and northeast side of the project. This will be consisting of native evergreen shrubs and evergreen trees.
I like that. I like that you have plans for the cover crop, because that is really important prior to everything happening, making sure that something's on the property to hold the soil there, even when you're moving things and putting, building the construction part, that still helps a lot. So I appreciate that. Thank you.
Thank you. And just for further context, at the public hearing, we presented some visual photos. I believe that's what you mentioned that earlier. And we do have an existing site that shows the native vegetation pre-construction, and then the fencing will also consist of an ag fencing. And these are just some of the examples of the landscaping and vegetative screening that we'll be installing for the project.
Thank you.
Thank you.
Questions? Is there anybody else here to speak on this case? Anybody else? Okay, I think we're ready to vote, Don.
ZC 24110, special use permit for a commercial solar energy facility with 4 conditions. Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Chairman Frankie Pretzel.
Yes. Yes.
5-0.
Good
Approved.
job. Congratulations. Okay, that concludes new business. On to other business. Authorizing a first extension of Will County zoning SCXT 24008 special use permit for zoning case ZC 22038 TTA Corp. Owner of record Jace Puther Cyril Jose, agent, and Justin Kugler of Kugler Law Limited, attorney. Joliet Township, commonly known as 1601 New Lenox Road, Joliet, Illinois, County Board District Number 8. I need a motion and a second, please.
Second, O'Gala.
We have a motion and a second. And Marguerite?
Yeah, so this special use extension is a first-time extension. The special use came before the county board August of 2022, and this is located actually just down the street from the last zoning case. This is the gas station at the northeast corner of Briggs and New Lenox Road. They got a special use permit for packaged liquor sales. And as a reminder, special uses expire if a permit's not issued or they legally establish the use within 2 years of county board approval. So what happened was the applicant obtained a building permit to get a beer cave, which is part of the liquor control ordinance requirements. And that building permit was issued and closed. However, they never came before the county board to get a liquor license issued, and their permit expired. There was some discussion with video gaming that came with them as well, which I think deferred them from actually moving forward with getting their liquor license. But since the special use permit expired, they wish to pursue their liquor license. They submitted a special use extension request. Since it was after the special use expired, they had to appeal our decision because we rejected it. They won their appeal through the Planning and Zoning Commission, so this is their extension request. If approved, it would grant them 180 days to secure their liquor license and appear on the county board to increase the liquor licenses for packaged liquor. With that, I'm happy to answer any questions.
I guess I just don't understand why I remember this case. We approved it. It seemed like a good place to give them the opportunity to sell packaged liquor. What does the gaming, I guess, is the change? And what
So
would that make?
it's my understanding with the current liquor control ordinance, again, we don't enforce it. That's the liquor commissioner's office. But with regards to the different classifications that get issued based on what is the use of the liquor sales, there's a provision within the liquor ordinance that says you cannot sell and pour, or if you have a packaged liquor license, you cannot change your classification to be a pour and packaged liquor classification. Like, it's just not permitted, and you cannot have two separate liquor licenses. So what happened was when they came forward, they were trying to figure out the best option forward with doing a pour license, which is what the state requires for video gaming. But the packaged liquor is what they were approved for land use, and land use would require another special use for the pour side.
So all these gas stations that have video poker or video gaming have a pour license?
Within a municipality, yeah. I'm not aware of any gas stations within the county that would have video gaming without a pour license.
I didn't know that.
I didn't either.
I see the applicant is chomping at the bit here, so we'll invite you down to the microphone. I'm sorry. Please introduce yourself.
Good afternoon. My name is Zubin Kamula. I'm appearing here on behalf of Mr. Kugler, who couldn't be here today. I just wanted to reiterate that Ms. Kenny's recitation of the facts is correct. The applicant did at all times continuously pursue getting the license, getting its building permit. We are on the agenda later this month, I believe on the 14th, for the liquor license. And the amount of time that passed between the special use permit expiring and the request for an extension was about a week. So, but the reason that the appeal was successful before the Planning Commission was just because we were able to demonstrate that we were continuously pursuing getting the license, and the gaming issues did come up, and that's partly what delayed the process here. But we're about 2 weeks away from wrapping this up if we get the extension.
Okay.
We have to have the special use permit in order to get the liquor license.
Got it. Got it. Makes sense. Okay. Member Friedman?
Thank you, Chair Pretzel. I have a question more for staff. This says it's in District 8. And I do believe that's incorrect.
This could be around the time the county board districts changed. So
Started.
yeah, back in 2022 was around the redistricting.
Thank you.
Nothing needs to be done to correct that today. It's Scribner's error. Okay. Okay. Thank you.
Thank you.
Any questions? Okay. All right. Thank you.
Thank you.
Go ahead.
Okay. Authorizing first extension, special use permit for zoning case ZC 22038. Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Chairman Frankie Pretzel.
Yes. Motion carries. Number 2, overturning the decision of the Planning and Zoning Commission and approving appeal APCD 24004, RE Land ILV, Inc., and Illinois Corporation. William Graft of Graft and Jordan, attorney for zoning case ZC 24066. A variance for location of open pits and shafts from the side property line from 50 feet to 0 feet, and variance for the location of open pits and shafts from the side property line from 50 feet to 0 feet in Wheatland Township, commonly known as the southeast corner of Essington Road and 127th Street, Bolingbrook, Illinois, County Board District Number 9. Can I please get a motion and a second?
Motion O'Gala.
We have a motion and a second from Williams. Okay, Marguerite?
So as mentioned earlier, with that first zoning case today, this is the appeal of the two variances that were denied at the Planning and Zoning Commission meeting in October. The variances are related to the fact that they want to do surface mining and just expand the footprint essentially of that existing quarry to the south and not have to adhere to a 50-foot separation. This would also allow them to use the existing access road on the existing quarry. With this, if the appeal is to be approved, two separate votes should be taken, one for each variance. And it does require a 3/4 majority vote of the county board for each variance to overturn the denial of the Planning and Zoning Commission.
Okay, so if the map amendment and the special use permits that we voted on earlier don't get past full board in 2 weeks, this would be dead in the water anyway? So,
Essentially, yes.
To give them a fighting chance, I feel like we should at least approve these so that if it does go through, then they.
Right. And likewise with variances, say the county board overrules the Planning and Zoning Commission, they are approved. They essentially have a year to establish the variances or apply for extensions.
I think it just makes good sense, but what do you guys think? It's comments? Fair enough.
Yeah, right.
So this would be like a movie called A Fighting Chance. So what's already been done, this gives them a chance to, and if it did not pass in 2 weeks, that this would be, I'm trying to get an understanding.
It allows them to mine from the mine that they have already.
Right.
To the new one, if they're able to have a new one, they'll be able to connect them, not have a big
But
bridge.
how would that affect the vote in 2 weeks though on this? So that will stop?
If the map amendment doesn't pass, nothing passes, and then the special use permits would have to also pass for them to do the work that they want to do.
Okay, all right.
But this just allows them to connect the two if.
Okay.
Did I explain that right? Okay.
Yes. And on top of that, should zoning be approved and they can't get permits, that would also potentially prevent the project from going forward.
Thank you. Dawn, I think we're ready for you.
First variance, 24-219. Did you want me to read it?
No, you don't have.
Okay. Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Frankie Pretzel.
Yes.
The second variance, 24-220. Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Chairman Frankie Pretzel.
Yes. Okay, both motions carry. Congratulations. Next on the agenda, amending sections 155-16, development review and approval procedures, common provisions 155-16.10. Colin, I see what you're doing here. Great work.
Right. So take the proposed text was sent to public hearing, and we received no comments online. We received no comments on the floor, and the Planning and Zoning Commission had no recommended changes. So the above text represented in the sign that Jesus is holding up for me, that the sign must be at least 3 feet in height and width, to be larger, and made with weather-resistant materials, printed uniformly with plain block-style lettering at least 2 inches in height, and approved by the zoning administrator prior to installation. So they could look something like this. That was done for the solar farm down south of Wilmington and Braidwood. And then additionally, for all notices, either by sign or by mailing, the notices must indicate the case, or adding in the case number and the description of the proposed zoning permit will be described in plain language as opposed to our wonderful zoning text.
Okay. So since this is a different committee altogether than we had just a month ago or 2 months ago when we talked about this, former member of the committee, Berkowitz, pointed out that she had a zoning case in her district in the past that made their own sign. They printed it with a Sharpie marker and it was on white backer, but it looked terrible. It was very hard to read. And we hear all the time at these cases, you heard some of it today, I didn't have enough notice, I didn't know about it, etc. So to kind of combat that, we decided we need to regulate the font. We need to actually tell them specifically what these signs need to look like or create them on our own. We decided we don't want to be in the sign making business, so we're going to be real specific on what those signs need to look like.
I should point out that it is for any sign that we do not issue, which is the one that we have for front yard signs, which is typically appropriate for the residential use.
So it's bigger, it's bolder, it's going to all be very consistent, and hopefully this does what we're looking for it to do. What do you guys think?
It's good.
Looks good. All right. Thank you for your efforts on that. I think this is a win.
Thank you.
Moving on. Number 4, private racetracks and residential zoning.
So we need to vote that we're approving this?
Oh, all right.
Yes, it does require a vote.
Recommendation approval. We have a motion, member Winfrey, second Brooks.
Thank you.
Sherry Williams, Denise Winfrey, Judy Ogala,
Yes.
Herbert Brooks, and Chairman Frankie Pretzel.
Yes. Thank you. Private racetracks and residential zoning districts, Colin.
Right. Oops. All right. So just for clarification, what we're looking at is a possible zoning text amendment. I don't believe this has been assigned to the committee yet. It's just something to get your attention. So when coming up with something brand new, I like to use the who, what, where, when, why, and how. And so what we have are Will County property owners and their guests, and they are using their off-road motorized vehicles such as dirt bikes and ATVs, and they're running around on their self-made trails on their own private property within a residential zoning district. There are no time constraints by code, and they're doing this for personal recreation. And it should be noted, it is not for commercial purposes. The reason why that is important is that the commercial use, if it's for commercial use, yes, we do regulate that, and it can only be permitted in the C6 recreational commercial districts, which is where we have the rod and gun clubs and golf courses. And then for the trails, the trail would not require a site development permit unless they're moving 100 cubic yards on a smaller lot or 200 cubic yards on a larger lot, or if it's within a floodplain, impacts a wetland, or affects existing stormwater drainage systems such as farm tiles. And then for regulations on the vehicles themselves, we define a recreational vehicle as this list of different vehicles. And the reason we do that is the only thing we regulate them about is where they are parked in a residential district. You can have no more than 3 in the larger lots and no more than 2 in the smaller lots. So
when you say parking, that's
I'm sorry, yes, that is
how long?
That is outdoor storage and parking in residential districts whenever. There is no time constraints. So it's basically to avoid mass parking of these recreational vehicles in your backyard.
So, question then.
Yeah, yes.
Can you go back to the prior screen?
This one?
But one more. Back, that one.
That one. Okay. Yay!
Not that one.
Oh,
The next one with the list. Oh,
Oh.
not that one. That one. Okay, so when you're saying like not more than 2 or 3, it's kind of a different here because you could have a motor home and a boat and a boat trailer. And those 2 different ones. I'm all confused. Camping trailer, tent trailer, I don't know what the difference is between them. So explain to me when you have the limit that you can have 3 of these or 2 of those.
right.
What would we allow? Snowmobile, and it's kind of small.
And any and all of these limit 3 outdoor parking only. If you park it in the garage or in a shed or other building that's been approved, there's no limit, but only outdoor parking is regulated.
And we currently allow 3 of these to be parked outside?
On the larger lots, yes.
I think it really depends on where you live. It can be trashy, but it doesn't have to be trashy. I mean, if you have a travel trailer, a boat and a boat trailer, and they're outside because they're not inside.
Right, and it is for all, these are for the residential districts. That does not apply to the A1
Right,
district at
no.
all. Okay.
Right. So minimum of 3. Do we have a limit on them now, or we don't have a
Yeah,
limit?
no, we did, this is what we have
This is
now.
what we have now.
This is what we have now. So for our purposes today, for the dirt track riding, as long as it's recreational riding on private property and trails and not for our commercial purposes, we have very limited scope of regulations for these.
I'm torn on this one because I love more than anything to see kids out riding their dirt bikes legally and off the roads. However, if you live right up to one of these and you hear that high pitch chainsaw noise for 3-4 hours at a time, it'll drive you insane. So it's a tough one.
So the question is, do you want to start looking at this?
I personally don't, but I'm just one member.
So we don't allow, or we do allow ATVs and dirt bikes now?
Yes, we do.
We do.
We do.
So
We just don't regulate them.
we don't regulate.
We don't regulate their hours of operation. We do not regulate the numbers. We do not regulate how close it is to an adjoining property.
Director, do you have a comment on this?
Yes, like Colin said, we will be, if it hasn't been on the agenda, bring it to executive committee for consideration for assignment. We wanted to bring this to your attention, though. This is resultant from complaints we've had from individuals, I think one in the Homer Township, New Lenox Township area, where you had a couple of property owners that had, private track constructed across 2 or 3 lots. And it was bothering some of the neighbors, the noise, the hours of duration, the hours and things of that nature. And the regulations that we can administer regarding that are very limited. I've also experienced this in prior years in other areas of the county, similar situation where you have neighbors that are riding the motorbikes on, again, whether or not it's constructed or not, excuse me, a path on their private property, driving the neighbors crazy with the motorbikes, with the sound. So it's a complex issue. And it may even take review of like state law with regard to OTVs and ATVs and recreational activity with A1 properties, and trying to define a scope as to how we can, address this, but be reasonable about it as well. But again, that's why we're bringing it to your attention. We were going to, it will have to be a request to be assigned, but we kind of want to get moving on this just to bring it to your attention. So.
I also think I have a guy that lives nearby me that must fix small engines, or maybe he runs some sort of a land. I don't know what he does, but he's got lawnmowers and chainsaws and things running all the time. So I don't think you can just pick on recreational dirt bikes. You almost have to make a noise ordinance. But that's just my opinion. What do you think? See your lights on.
Oh, I just had my light on from before. I can see them, listen, I live out in the country, so we have people that run around all the time. I'm not going on anybody's property, but the noise can be bothersome if it would be during, in my opinion, during the evening. And obviously it's not safe if you're driving at night and it's dark. But they do have headlights on a lot of these.
The dirt bikes usually don't.
Dirt bikes don't?
The ones that are street legal do, but most dirt bikes do not.
Yeah. I don't know. We can think about it, talk to our caucuses, maybe see what they think, and then whether we bring it back or not. I think that's what I would like to do. Okay.
We're gonna kick the can down the road.
Sounds good.
Did you have a comment?
I was just going to comment. So I live in Plainfield and we do have had issues with kids on their dirt bikes. It's fine if they're in your backyard, but it's when they start crossing over into other people's yards and leaving rivets in their dirt that it becomes an issue.
That is already illegal though.
Yeah. They got to get caught though, right?
Well,
But I mean, there are some issues in the country. There's no problem. Bigger yards, no problem.
yeah.
Create a dirt path with the jumps and stuff. Now we got dirt in the equation. So it can be a thing.
I think we did also get a letter from down in Wilmington, and it was all on private property, but it's next door to residences. And them and their friends were coming on, they're riding the bikes. And so people in the surrounding properties weren't getting property damage, but they're getting the constant noise and disruption. I thought I remembered that. So it's something to look at for sure.
And,
Go
you know,
ahead.
I don't want to compromise confidentiality or identify specifically property, individuals, or location, but in one instance recently too as well, there was a child that's an autistic child that's noise sensitive,
Yeah, that's
and
different.
that was causing issues as well. So.
Yeah, that's tough. How do you fix that? Okay, thanks for that. We'll circle back. Solar status report. Margie.
It's up to you, but in the months past, it's just helpful to kind of touch base of what the solar cases have been with land use and come before the commission or committee. Would you want me to update you continuously?
Since we have a new committee, I think it's important that we
Okay.
kind of know where we are today.
Yeah, so for 2024, we had 24 submitted zoning cases. 14 have been heard through to county board, 3 of which were denied. 4 were withdrawn because the application was incomplete after 60 days. So our zoning ordinance basically says that's a sign that they're withdrawn, they're not pursuing. We have 7 currently in review with the land use department that's incomplete. So if they do complete, they'll come before the commission or committee. And then 4 we have in the public hearing process. 3 of them you heard today. And then we have another one, I believe, going to county board in February. So those are pretty much in total of approved acreage. It's 1,046 acres, give or take, and approved megawatts is 131 megawatts with projects. I believe in terms of permits, we're maybe 2 handfuls with permits coming forward. I believe the first big set are all issued except for one with landscaping being their remaining inspection to pass. And that's all I have.
Go ahead.
So I have a question regarding this is that I know that we allow self-reporting for solar facilities. So why do we allow self-reporting versus us going out? There aren't that many solar facilities in construction at one time. I know of one that was a complete failure as far as they were reporting something that wasn't true, and it wasn't until local people complained about it that we actually went out and looked at it and saw it. I live I drive past solar all the time, so I never know really what state it is. I don't remember where it is. I attend these meetings all the time, and I'm on the committee, but it's not like you can remember, oh yeah, Smith Road and such there at this stage, and what's all required at all these different stages, and I know they go through various different stages. So if you can answer that self-reporting and who allows that, who doesn't allow that, why do we do it?
I'm sorry, but I don't understand the self-reporting question.
I thought with specifically the Moni Township one off of Route 50 and Offner Road, it said that, from what my understanding is, we had some complaints about they're in violation with the EPA. They didn't have ground cover. They still don't have ground cover. They threw some sheep in there, lambs or goats or whatever we allow. These poor little things were just huddled around. I'm not even sure what they were eating. We had a lot of runoff, drainage. They didn't have sufficient drainage. It's built on a clay hill, so that causes a lot of problem. A lot of water was running off with that. And my understanding from talking with people from Soil and Water is that they were self-reporting to say that they had met this and they had done this and they had done this, but yet that never was done.
So in terms of, I believe there is a self-reporting component to their NPDES permit to keep track of storm situations and to be in compliance with the state requirements for the EPA with that type of permit, who issues it. In terms of the county, it's my understanding we ask for copies of their records to make sure that they're in compliance with the state and that permit.
Yeah, but this specific property, I don't know how they got the approval for so many things since there is no coverage. There's very little coverage. In one part, because the soil is better at this part of the parcel versus the other strictly clay, they're having a very difficult time doing that. I know I walked out there with the Soil and Water members, and because it's on a hill, they made them put those bats, those black bats, and to slow the water from running. That wasn't there before. So I don't know where we come in. I'm not sure where we come in on that. Do we look at that at all? Or do we go out and look at that, or is that strictly Soil and Water's responsibility?
In terms of the stormwater runoff, that's reviewed with the engineers as part of the site development, and there are inspections throughout the permitting process. So upon, review of the site plan and everything's conforming, they usually will require a silt fence inspection before they actually sign off final approval for a permit to be issued. And then there's several inspections, the last of which is usually they need to see the site growing ground cover, and that has to meet a certain threshold. Otherwise, they cannot sign off approval.
Oh, that project is a total fail on every one of the things that you mentioned. That's why I'm asking about this, because if that is true, then I don't know who is the engineer or whoever does these sign-offs to say, yeah, that happened, because I know it didn't happen. And they had everything, all the solar panels were in, the fencing was up, the whatever, the storage collectors there, all that was on site. And I believe I think it was operating because I heard the humming when I was there. So I'm just confused how that could have possibly have happened. I always go back to this, but that's why I refer back to it, because that is a problem we have to look at never happening again.
Is this the solar farm on Governor's Highway in Offner?
Yep, Ralph.
That permit's still open. So, the permit's issued, they can do the work, but final inspections have not been completed on it. So landscaping's one of them. I believe engineering would be another that would need to be completed to basically close out the permit.
Okay, so maybe for my clarification, we go through the different stages with this. Maybe we look at, and I can talk with you offline, but maybe we look at, today we had 3 solar companies come for us. What stage are they in? They're in phase 1. Maybe it's 10 phases to get to the end, so we can know what phase it is. So when you give us a report, and maybe it does say phase 1, phase 2, what have you, I'm not sure because my iPad died, but if we could have a good understanding of that. So if I'm driving past a lot of these that were just approved today, passing to the full board, that I could understand this is phase 1, this is phase 2, what's outstanding on them. I know that one in particular had trouble with the EPA, had violations against them on that. So that's what's confusing for me, because like I said, I thought they already were generating solar because I heard the humming going on there. So is that not true? It wasn't up and running?
It's my understanding with the site development still being open, that they shouldn't be. But I do know, in terms of some of these solar projects, they do come in as two separate permits. One will come in for the electrical components as a building permit, and then the actual groundwork would be the site development. And if the building permit, electrical codes, things like that get issued and the site development permit remains under inspections, they basically have an occupancy permit to start working and running. So something going forward is we've basically just required one permit instead of breaking it up between two.
Oh, so that could help us then, I'm guessing.
That could, yeah. It gets a little hard for enforcement if we have two permits, which is.
Because one, it
Yeah.
seemed like, it looked like the electrical looked like that was good, but the other part wasn't done. So now we use one. I like that. Thank you.
Yep.
Questions? Okay. Colin, Land Resource Management Plan update.
The final draft, not final, the draft of the addendum to the Fairmont plan will be forthcoming, probably at the next meeting. It's for you to get a look at it, and then we'll, if you think that it looks okay, we'll send it out to public hearing and then bring it back.
Sounds good to me. Okay. Thank you. All right, moving on to reports, communications, correspondence. I, as chair, do not have anything to say this afternoon. Do we have any comments from committee members? All right, Judy Ogala.
Thank you. I don't remember who I spoke to, probably Marguerite, maybe David, I don't know. But I have a landowner out in, it's in Will Township, and they had a solar company come up to them and say, hey, we'd like to put solar on one of your farm buildings. This guy is a hog farmer, so he has lots of low buildings, okay? And he wanted to agree to that, and by doing that, then he gets, to use some electricity or something like that. And then the issue that came up was because he has an old farmstead, and as we all know, or some people don't know, years ago when you farmed, and even now, you keep your buildings very close together because what's important for you is growing, not your space that you're going to use for your building. So you kind of keep everything close together. So there was a house and this one ag building very close to the road within the right of way, because back then there weren't those restrictions, right? So I know that the solar company was coming in, applying for variances and everything like that, that he needed to put the solar panels on the accessory building. But if he was going to put those same solar panels on the house that is also in the right of way, he wouldn't have to do that. So I'd like to have more cohesiveness there, because in this sense, his accessory building is much larger and more feasible than his home to put any solar panels on top of. And if we're allowing it on the house, I don't know why we wouldn't allow it on the accessory building. And we don't let people typically build within the right of way nowadays unless they've gotten a variance, in which case he wouldn't be in having a problem here, but he has to get a variance to put it on top of the accessory building. So if we could maybe have some information on that so we can look at it and see if there's something we can do to make it more uniform between the two different types of structures, the home versus the accessory building. And this, of course, I think would only apply to the older properties that have been built many years ago and didn't follow the same rules we have today. That's the only thing I have on my mind. Thank you.
Thank you. Any other comments? All right, Director, do you have any comments for us today? Happy New Year to you as well.
January 2nd, we're here.
All right, we're on to public comment. I see we have a very patient person here who's been with us for 5 or 6 hours. And I apologize for that. That's sometimes how it goes. But welcome. Yeah, please step up.
Thank you. Thank you for having me.
Start with your name, please.
Sorry, my name is Lauren Herrera. And I have a petition that I wanted to share. It's currently 369 signatures, and I wanted to read it. please. Dear City Council members and Planning Commission, I am writing this appeal not only as an individual, but as a single mother and fully qualified counselor, deeply connected to the divine source and committed to social justice. Like many others, I am currently without permanent housing. This personal challenge has only highlighted the urgent need for solutions to the housing insecurity many of us face. It is with this in mind that I advocate for the adoption of tiny homes, fully compliant with an updated zoning code as a practical and compassionate solution. Tiny homes, while modest in square footage, provide full functionality and offer a viable response to our community's housing crisis. These dwellings have the potential to alleviate the strain on our housing market, providing affordable, sustainable, and environmentally friendly living options. I urge the City Council and Planning Commission to consider revising the zoning code to allow for the construction and legal occupancy of tiny homes in our area. By amending the zoning regulations, we can create a safe and accessible path for individuals and families who are struggling with housing insecurity. Tiny homes have been successfully implemented in numerous communities across the country, offering not only shelter, but also fostering stronger, more resilient neighborhoods. I believe this can be replicated in our own community, helping those in need while supporting a more sustainable and inclusive future. Tiny homes can be classified as accessory dwelling units, ADUs, and special use permits could allow them to serve as primary residences. This approach supports simple, mindful living while addressing the ongoing housing shortage and providing homeowners with cost-effective and flexible alternatives. I respectfully ask for your support in making tiny homes a legal and viable housing option in Will County, Illinois. Everyone deserves a safe and stable place to call home, and tiny homes can be a part of that solution. Together, we can turn this vision into a reality for our community. Sincerely, Lauren Densman Herrera.
Thank you.
Thank you. Do I stay here or do I go?
No, you can go back.
Okay, thank you.
Thank you for your comments. This is just an opportunity for public comment where it's not on the agenda. We're not going to have a big discussion about it. But thank you for giving us something to think about. Okay, last chance for comments here. Okay, do we have an executive session? Are you our new attorney? Okay, what's your name? Cole. Sorry, I waited till the end. But fortunately, we didn't need you. Yeah. No executive session then? All right, well, you would know. Looking for a motion to adjourn.
Second.
We have a motion, we have a second, all in favor? Any opposed? Okay, motion, meeting's adjourned. Next meeting will be February 6th at 11 a.m. right here at the county office. Yeah, I know. I felt like that was enough for two.